Time is 11:22 a.m. The Committee on Criminal Jurisprudence will come to order. Clerk will call the roll.
Chair Moody.
Present.
Vice Chair Cook.
Here.
Representative Bojani.
Here. No.
Representative Bowers.
Here.
Representative Darby. Representative Harrison.
Here.
Representative Leach.
Here.
Representative Christina Morales.
Here.
Representative Schatzline.
Here. The quorum is present. Members, this is a reminder. If anyone is present that wishes to testify on any of the bills today, I'm going to need you to register at the kiosks that are located in the hallways behind the committee rooms. If you require assistance in registering or testifying, please just notify our staff and we'll be happy to help you if we're able to. I do want to note that we have a number of bills that we've set today, and judging by the capacity in the room, some may have sparked some interest. In keeping with our, what we've done, keeping consistent with our other meetings, we are going to have this high-tech device counting you down, and you'll have 3 minutes for your remarks. A little yellow light, and the red light will tell you that you've got to stop. And that doesn't include questions if members want to ask you questions, but that is for your prepared remarks, if you could keep them to that time limit. So we were respectful of everybody. I know we have people that have come in and out of town to testify today, so we want to be respectful and make sure everybody has the same opportunity to weigh in on their bills. Again, just for the members that are sitting here, I tried to organize these bills to be heard in seniority order, but there's always a little bit of flexibility depending on witnesses and availability. So we'll try to keep to that just for people's planning purposes. But that's how we'll try. That's how we'll attempt to keep this as orderly as possible. With that being said, actually, members, anybody have any comments before we start? No? Okay. Chair lays out House Bill 1300 and recognizes Mr. Guerin to explain the bill.
Thank you, Mr. Chairman and members. House Bill 1300, this will be its third trip here. It hadn't done well in the Senate, but hopefully we'll overcome that this time. Tampering with almost any kind of evidence is a third-degree felony, and while it's a serious offense, especially in crimes considering homicide and assault, there's instances where the penalty for tampering far exceeds the punishment. The unintended consequences were brought to me by my former DA, and my new DA is they put in a card in support of this. Like drinking while driving is a Class B misdemeanor but the individual throws a beer can out of the car window, he's facing a third-degree felony for tampering with evidence. And so he's going to be charged with a misdemeanor for DWI and then a felony for throwing a beer can out the window. And what this bill does is it puts the tampering with evidence penalty, it ties it to the crime. So if you're charged with a misdemeanor, tampering with evidence is a misdemeanor. If you're charged with a felony, tampering with evidence is a felony. And essentially that's all that this bill does. And I'd be happy to stand for questions, and if anybody has them, if not, I reserve a right to close.
Okay. Members, do we have any questions for Mr. Guerin? No? Okay. Real quick, let me just make sure. Is there anyone wishing to testify on, for, or against House Bill 1300? Okay. If not, we recognize Mr. Guerin to close on the measure.
I close, and I apologize for taking so much time.
For those other members sitting here, what you just saw was a master class in presenting your bill. Please take note. If there's no objection, HB 1300 will be left pending at this time. Is there any objection? The chair hears none, and the bill is left pending. Chair lays out House Bill 1907 and recognizes Mr. Anchia to explain his bill.
Thank you, Chairman Moody, Vice Chair Cook, members of the committee for this opportunity to present what we consider a very important piece of legislation. As all of you know, the Texas judicial system employs a number of specialty courts that offer low-level offenders correctional avenues as alternatives to incarceration. This has been well settled in Texas law for some time. And these rehabilitative programs include veterans treatment courts under Chapter 124. They include mental health courts under Chapter 125 and other qualified courts under Chapter 76, Spot 011. And as all of you likely agree, they help reduce recidivism, the strain on the already overburdened penal system, and they give offenders a chance to receive the real rehabilitative help that they need. So upon successful completion of these programs, graduates can have their records expunged. In fact, Chapter 55 of the Code of Criminal Procedure guarantees, graduates of these pretrial intervention programs as a right the opportunity to have their records expunged. However, we're not seeing records expunged and the benefits of this program inure to these participants in the diversion courts because the process often requires a separate application, $290 in fees, and a return to court. So in places like Dallas County, you only have about 50% of the participants in these drug courts actually getting the expunction that they have a right to after participating. So what House Bill 1907 does is it amends Article 55 of the Code to make expunction orders automatic upon the completion of the pretrial intervention programs. Under the bill, the defendants are still required to submit all of the necessary information that is required to be in the petition of expunction already, which is already an application to the court. Members, there are other bills moving through the process, and I just want to distinguish this bill from others. This bill deals with pretrial intervention, whereas other bills that you may hear or have heard deal with post-indictment interventions. So that's an important distinction. Both are laudable and important. They just occur at different parts of the process. And in Dallas County, these alternative courts are offered on a pretrial basis, pre-indictment basis, rather. And so with that, members, I humbly ask the chair for the opportunity to close, recognizing that there is no right that exists. Thank you.
Well, hold on. I think people have a series of questions for you.
Sorry.
No, I'm just kidding. Anybody have any questions for Mr. Uchia? No. All
right.
We will
Psych.
reserve your option to close.
Thank you.
We do have a couple of witnesses registered. The chair calls Paige Williams.
Good morning. Thank you, Chair Moody. My name is Paige Williams. I am here representing Dallas County Criminal District Attorney John Crusoe in support of House Bill 1907. As Representative Anchia has pointed out, what we have seen in Dallas County is that unless it is a pretrial diversion program in which a prosecutor and a public defender are shepherding the participants, that the remaining individuals in the other programs are not actually moving forward with an expunction. Currently, the law says that at the conclusion of a pretrial diversion program, the judge simply has to say, you are entitled to one. What 1907 does is it streamlines the process. It cuts out the red tape, and it cuts out all the loopholes that an individual who has successfully completed a pretrial diversion program has to go through to receive an expunction. The other thing this bill does is that it does carve out a tiny exception for us to maintain a limited amount of data points for the purposes of improving pretrial diversion programs, keeping a track on recidivism, and giving the counties that participate in these specialty courts, giving them the opportunity to compete for much needed grants that are highly competitive at the federal and the state level. With that, if you have any questions, I'll be happy to answer them.
Fantastic. Thank you. Members, do we have questions? No. Thank you.
Oh.
Chair calls the most honorable Larry Phillips. I hope you come to a lot of our hearings. I have fun.
Yeah, well, I wasn't planning on being back this soon, but I was honored to have Chair Anchia ask me to come talk about HB 1907. I'm Judge Larry Phillips. I'm a judge of the 59th District Court in Grayson County, Texas. I have a general jurisdiction court, and I'm here. I register on the bills just because, as a judge, I think probably that's what I need to do. We'll be registering in favor on the bill, another bill later for our association.
Got it.
One of the great honors I have and why I wanted to be a judge is I get to have a specialty court that I'm involved with. Mine's post-adjudication. It's not pre-adjudication that would apply in this situation. Specialty courts have a 30-year track record across the United States and Texas of success, reducing recidivism and transforming lives. It's those individual lives that keep me excited every other Monday when I have that group comes and I challenge them to succeed. It's a rigorous program. All of these are. They're rigorous. You got to get a job. You got to get a good place to live. You got to come to counseling. You call in and get drug tested anytime they tell you to come in. You have to call every day, multiple times. It's a rigorous program. And so what we're doing here, this applies to mental health courts and veterans courts. In what we're doing is we're changing Chapter 55 of the Code of Criminal Procedure to really allow these participants to have kind of what they were promised at the beginning. These are, again, pre-adjudication, and these programs and specialty courts are collaborative. We have prosecutors, law enforcement, defense attorneys, the probation department, everybody together, and we have amazing policies that have been adopted at a national level. This summer in Houston, I'd invite you all to come to the National Drug Court the National Association of Drug Court Professionals is having their annual conference in Houston this year. And it's a great opportunity for you to learn more about specialty courts. I'm Vice President of the Texas Association of Specialty Courts, and I'm not testifying for them on this part, but just to let you know that we favor opportunities for our graduates to continue to succeed. If you have to go to your boss and say, oh, boss, I need to go to court. I thought you'd already got rid of all this. I thought you'd already taken care of that. No, and then you have to explain that they're not in trouble again, but I'm going to get this expunged. Well, tell me again what happened, and they want to get in the past. They generally have to hire a lawyer. I am shocked, not only these participants that are eligible, but non-disclosures, which we're going to hear about, y'all got some bills on, and other expunctions, people don't come and ask for them because of the cost, expense, and they don't like coming to court if they don't have to. So I wanted to come and answer any questions about this. Again, it applies to veterans, and they're remarkable people. They deserve this opportunity. Those that are mentally ill, they didn't choose that opportunity that placed them in those situations. And then the other one are these pretrial diversion courts, which is kind of a new area that will be added. And those are great opportunities generally for youthful offenders. The prosecutors are involved in these processes. In fact, mostly in the big counties is where they have these pretrial diversions, and the prosecutors are shepherding as we heard them along. Glad to answer any questions.
Judge, thank you. Members, questions for Judge Phillips? Comments, concerns, jokes? No? All right.
Thank you.
Judge. Is there anyone else wishing to testify on, for, or against House Bill 1907? Chair sees none, recognizes Mr. Anchia to close on the measure.
Thank you, Mr. Chairman, Vice Chair, for the opportunity to lay out this bill. Thank you for the Honorable Judge Larry Phillips for coming. Always good to see him here in the Capitol.
Most honorable.
Most honorable, the highest and most exalted, Honorable Larry Phillips. And with that, I close, Mr. Chairman.
Thank you, Mr. Anchia. All right. Members, if there's no objection, HB 1907 will be left pending. Is there any objection? The chair hears none. House Bill 1907 is left pending at this time. Chair lays out HB 1910. Recognizes Mr. Anchia to explain his bill.
Thank you, Mr. Chairman and members of the committee. We're going to be dealing in this bill with forgery. Forgers are repeatedly stealing from mom and pop shops in my district and likely the districts that you represent, and oftentimes they get away with practically a ticket, Class C misdemeanor. And just as a note, Class C misdemeanors are punishable by a fine of usually about $500 if they're prosecuted at all. So recent case law has determined that the criminal offense structure for forgery is based on the value of the property or the service being obtained or attempted to be obtained during what is called the utterance, which is the transfer, the passing, or the publishing of the forged writing. We amended the forgery statute in 2017. There's been a decision by the Sixth Circuit Court of Appeals, which has created prosecutorial uncertainty in charging, and that is, there are two cases actually, Lennox versus State and also State versus Green. They changed the interpretation of sentencing. So according to Section 32, Spot 21 of the Penal Code, forgery is the act of creating any fraudulent writing made to obtain or attempt to obtain a property or service. Currently, the criminal offense structure for forgery is based on the value of the property or service being obtained. For example, if I go to a 7-Eleven and I'm purchasing a candy bar and I try to utter or pass a forged $50 bill, that would be a Class C misdemeanor, even if I had $50,000 in forged bills in my backpack. And that ultimately was discovered subsequent to arrest and passing this bill. So under the current interpretation in Green and the other cases, they say, no, it's only a Class C misdemeanor, even if they discovered the $50,000 in my backpack, because I only tried to obtain a thing of value for the $50, right? So what we're trying to do here is create a presumption that that your intent in carrying that money around was to also pass it at some point. And that allows us to, allows prosecutors to look at the actual facts of the case and prosecute the forgery charge all the way up to that $50,000 that would have been in the bag. Now, let me give you a couple of real cases exemplifying issues. You had a defendant respondent to an offer-up post to buy an iPhone. They paid $360 in forged money. The police responded and were able to locate the defendant's vehicle, where they located an additional $2,300 in forged money. But this case, because the post-Green uncertainty had to be pled out at a Class B, okay? Even though there was far in excess of the sentencing ladder amounts to get them on a higher charge, right? A defendant passed a $10 bill but was found with almost $300 in forged money. This case ultimately got dismissed because the Class C was almost not even worth the prosecution time, even though there was forged money in an amount far higher than what was ultimately sought to be passed. So what this does is allows prosecutors to look at the entire facts of the case, say, hey, you've got forged money. We're going to create a rebuttable presumption, but a presumption that you intended to pass that money. That wasn't a stage prop or anything like that. You had this forged money, and it was your intent to offer up that money for a thing of value. You can rebut that. You can rebut that. But it'll make it clear post-Green that that was the person's intent. That's what we got, members. And with that, I humbly ask you for an opportunity to close.
Yes, sir. Members, do we have questions? I appreciate the explanation. No? All right, we do have one witness registered right now.
Thank you.
The chair calls Philip Clark.
Good morning. Thank you, Chairman Moody and members of the committee, for having me here. I'm pleased to speak on behalf of this bill, and I'm grateful to Representative Anchia for bringing it forward, because as a prosecutor, I represent the Dallas County Criminal District Attorney's Office, and John Cruzo is my boss there, and I represent him in the Financial Crimes Division of our office, and I work...
And your name for the record, just before we start into your...
I'm so sorry. Yes, it is Philip Clark.
Okay, and you're here representing...
The DA's office in Dallas County, John Cruzo.
And you said on behalf of the bill, you mean you're in support of the bill?
I am speaking in support of the bill.
Perfect.
Thank you, sir. I work in the Financial Crimes Division of the office, and I work on forgeries. And in doing this work, I have seen the challenges of applying the statute in 3221 in the cases that we see on a day-to-day, practical, real street level. As Representative Anchia explained, there is prosecutorial confusion resulting from the cases Green and Lennox that came out in 2020, a couple of years after the amendment was made to the statute, which was in 2017. The presumption allows a very common sense approach for us to be able to look at the facts of a case and not be in a situation where, as the Representative Anchia indicated, the DA's office would have to perhaps dismiss a case. And that would probably be if it was down to a Class C misdemeanor, meaning $100 or below, because our office no longer has jurisdiction over the case. We cannot prosecute it at that stage. It could be for bringing it down to a Class B or a Class A, But I can tell you, it's very frustrating to prosecute a case as a Class B or a Class A when you know that you found $5,000 of counterfeit money in their backpack. This bill would allow us to proceed on that case in a way that makes sense. The person has already spent some of that. We know that they really intend at some point to spend the rest of that, and will allow us to go forward with these cases and not ignore the facts that we're finding when the law enforcement make their arrest. I welcome any questions.
Members? Okay, all right. Thank you so much, Mr. Clark. Appreciate your time.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 1910 at this time? Chair sees none, recognizes Mr. Anchia to close on the measure.
Thank you, Mr. Chairman, Vice Chairman, and members. If there are no further questions, I close.
Thank you, Mr. Anchia.
Thank you.
If there's no objection, HB 1910 will be left pending. Is there any objection? The chair hears none, and HB 1910 is left pending at this time. Chair lays out HB 1762 and recognizes Ms. Gonzalez of El Paso to explain her bill.
Thank you, Chairman. Thank you, Vice Chair Cook and the committee members. I'm here to lay out House Bill 1762, and Chairman Leach will remember this because I have been trying to pass this bill since our freshman session. This is a really simple bill, member. It literally deletes 5 words. 5 words. That's all we want to do. Why? Because ask yourself, do you believe that young people should be arrested or criminalized for their relationships? Probably not. You wouldn't want your niece, your nephew, your family member, if they're between the ages of 14 to 17, just because they're in a consensual relationship, for them to be criminalized, and or for the professionals helping them, teachers, doctors, etc., therapists, to also feel that they have to report this relationship. So what 1762 does is delete 5 words. It changes the affirmative defense, and it makes it open and available to all youth, so that no youth, regardless of their relationship, is penalized, and the reporters specifically aren't put in the ethical dilemma of choosing between providing the best care for the youth that they serve or enforcing the law in a discriminatory manner. In years ago, the affirmative defense was, we added and of the opposite sex, and we just want to strike those words. And with that, I would love the opportunity to close when it is available, and I stand open for any questions.
Okay. Members, do you have any questions? And just to clarify, and I think this is an important point for this, in this measure, these are affirmative defenses that can be raised as part of the process. Doesn't stop someone from being charged or arrested, but
right.
They have to assert this as an affirmative defense. And right now, the affirmative defense is not, essentially not available to some young people because of the nature of their relationship.
Yes.
Okay. Thank you.
Thank you so much.
I know we do have a couple of witnesses. Chair calls Will Francis. I'll go back. Chair calls, is it Louis Appel? I could have got the pronunciation of both your names wrong, and I'm not sure if I did or not.
No, you did perfect.
Oh,
Louis Appel.
okay.
Exactly.
I was debating. It'd be good to state your name, whom you represent, as someone other than yourself, and your position on the bill.
Great, thank you. Good morning, Chair Moody, Vice Chair Cook, and committee members. My name is Louis Appel. I'm a primary care pediatrician at People's Community Clinic in East Austin. I'm here to testify in full support of HB 1762 on behalf of the Texas Pediatric Society, People's Community Clinic, and the Texas Medical Association. This piece of legislation directly affects me and over 4,800 pediatrician members of the Texas Pediatric Society who care for adolescents every day. The passage of HB 1762 is necessary to ensure physicians across Texas can provide best practice, ethical, and compassionate care to all our youth. As you know, physicians are mandated reporters of child abuse and neglect, and this responsibility is taken seriously. As the law currently reads, physicians are forced to report relationships between adolescents of the same sex that they would not be required to report for their opposite sex peers in similar circumstances. The current laws put an unnecessary strain on the patient-physician relationship and create an ethical quandary for healthcare professionals. It's our ethical responsibility as physicians to provide comprehensive and non-judgmental care to all our adolescent patients, regardless of sexual orientation. But the current obligation under state law to report these youths to CPS is in direct opposition to that. When physicians report patients are pushed down a path with the CPS system, potentially traumatizing the youth and their families, destroying the trust between patient and physician, and using up the precious bandwidth of our state CPS intake system. The current inclusion of opposite sex in the affirmative defense for indecency with a child creates an undue time, financial, and ethical burden on healthcare professionals in the CPS system. It delegitimizes the reality of many youth's adolescence, is unnecessarily discriminatory, and will push youth away from sharing potential pertinent health information for fear of penalization. HB 1762 will ensure the physician-patient relationship is not compromised, eliminate unnecessary CPS reports, and allow physicians and healthcare providers to provide the best possible care to all Texas youth. Thank you for the opportunity to testify in support of HB 1762.
Thank you very much. Members, do we have questions? No? No? All right, thank you so much. Chair calls Will Francis.
Good morning. My name is Will Francis, and I am the Executive Director for the National Association of Social Workers Texas Chapter, and I'm here to testify in favor of HB 1762. I would like to thank Chairman Moody and the rest of the esteemed committee members for the opportunity to testify today. HB 1762 by Representative Gonzalez updates the law by removing qualifying language relating to opposite sex couples in Texas's Romeo and Juliet law, ensuring the inclusion of same-sex, consensual teen relationships under these protections. Any activities these youth engage in are not criminal, per the Supreme Court case of Lawrence versus Texas. And therefore, HB 1762 simply aligns the penal code with the law. More importantly, HB 1762 ensures that social workers are able to provide youth with a safe and supportive space where they can open up about their relationships. As a former CPS caseworker, I know how vital it is for youth to know that they can talk about what is happening in their life openly with a social worker or other mental health provider. No child should feel that they have to withhold details or particulars of their life simply because the law treats consensual relationships differently. Updating this law to ensure that all Texas teens are treated equally remedies any confusion in the law, and in addition, social work respects the identity and dignity of all who identify as LGBTQIA+. As the law is currently written, social workers in Texas could be held liable if they do not report a consensual same-sex couple due to mandatory reporting laws. This current law places mental health professionals working with LGBTQIA+ teens in situations where they must report actions that are not actually criminal encounters. We support the changes, and I'm open to any questions.
Will, thank you. Members, do we have questions? Nope. Thank you so much.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 1762 at this time? Chair seeing none, recognize Ms. Gonzalez of El Paso to close on the measure.
Thank you, Chairman, and thank you, Vice Chair Cook. There are real problems in society. There are kids who are actually being abused. There are CPS workers who are already overburdened. All we're trying to do is say, let's align the penal code with what the courts have already said, make sure that our doctors and our healthcare workers, our social workers, our therapists aren't feeling this tension or conflict, and really making sure that we aren't creating undue burden in our system. I recognize the politics of the world, but this is about our little ones. Our little ones, and are they really committing a crime or not? And the truth is they're not. We're just trying to make sure that their relationships are not criminalized, and that's literally all we're trying to do. So with that, I close, and I hope the committee will favorably report this bill out. I will say this committee did report this out favorably a few years ago, and it actually made it to the floor, and then there was a deadline day, and damn those deadline days. But we hope that the committee will do that again.
When was it voted out of committee?
Not last time, because I did it 2 times before, like
19.
19.
Okay. Thank you. Members, do you have questions?
It might have been 17. I don't want to lie. 17 or 19.
Okay.
I'm getting old.
Any questions for Dr. Gonzalez? Sorry, I should have been more.
All right, thank you.
No, thank you. All right, if there's no objection, House Bill 1762 be left pending. Is there any objection? Chair hears none. House Bill 1762 be left pending at this time. Chair lays out House Bill 1730 by Mr. Schaefer and recognizes Mr. Schaefer to explain, or is it Dr. Schaefer? No?
Thank you, Mr. Chairman and members. Under current Texas law, if a man exposes himself in front of a woman and gratifies himself, that is Class B misdemeanor. If he commits a second offense, that's a Class B misdemeanor. If he commits a third offense, it's a Class B misdemeanor. The perpetrators of indecent exposure are primarily men, but the victims are primarily women, usually young women. And what we have seen in my community is that there are some repeat offenders out there. Now, I am loath to increase penalties in the criminal law because usually it doesn't work. Like, just enhancing penalties, usually, that person is not necessarily thinking about, what the penalty might be before they do it. We're talking about repeat offenders. And in fact, under Texas law, the second time you're convicted of this, you do go on a sex register. But yet you still have some repeat offenders that continue to offend. So you've got somebody who's already been arrested, convicted, and now they're doing this again. This person has a problem, and yet our law does not increase the punishment. And so I believe we're going to have a couple witnesses here from Smith County out in East Texas that can speak to some of the real world impacts on women and what we can do in this bill to make some enhanced penalties. So the second time the offense is committed, it would be a Class A misdemeanor, and if it happened a third time, it would go up to a state jail felony.
So you have a ratchet up, second and third? Okay. And I'll ask you, and I want to thank you for putting us in touch with folks back in your county to talk through some of the issues that they were facing. I think it helps us understand what you're working on. Just so people are clear on the conduct, right? Indecent exposure, I won't go through, but it's 21.08 in the penal code if you all want to look it up. So the key language you used is with the intent to arouse or gratify the sexual desire of any person, right? And then you have to be reckless about whether someone else is present while that's going on. So let's be very clear about the conduct we're talking about, right?
Yes.
So this is an accidental exposure. Right. This is, right.
It's
this isn't
not
public urination.
It's not public urination, some of the homeless issues that you might deal with, because in those scenarios, there's not an intent to gratify.
Yep.
So.
Okay, I just want to be sure we're zeroing on what type of conduct we're talking about. Thank you. Members, do you have questions for Mr. Schaefer? No? I know we do have a couple of witnesses. Thank you. So I have a DA and a judge. It's hard. Who do I defer to? The DA, okay. Chair calls Jacob Putman, sorry.
Thank you, Mr. Chairman, committee members. I'm used to deferring to the judge.
I know, that's why I didn't want to put you in a weird position either.
My name is Jacob Putman. I'm the Smith County Criminal District Attorney. I'm here for HB 1730. As Representative Schaefer laid out, this is a crime that we see a significant rate of recidivism. It's certainly not a rampant, widespread crime across the state of Texas. This is not going to apply to most of the citizens of the state of Texas. We see a small number of people in the criminal justice system who are committing really a sex crime. That's why the legislature has long required a second conviction to register as a sex offender. But what we are seeing is people who commit this offense over and over and over again, knowing they're not going to face any more punishment. They're already registered as sex offenders, and it acts as no deterrent to them. DPS currently has 387 people who are registered as sex offenders for second convictions of indecent exposure alone, so misdemeanor crimes alone. Of those 387 people, 40% of them have more than 2 convictions. So these are people who've been convicted once, convicted twice, and 40% of them have gone on to commit it more than 2 times. 20% have 3, 14% have between 4 and 6, and 6% have more than 7 convictions, with several of them having double-digit convictions of indecent exposure. These, as you can see, while it's a small population, this remedy of providing an enhancement is narrowly tailored to the people who continue to repeat these crimes. The second conviction, this bill would make it a Class A, a third conviction a state jail felony, not only increasing the potential punishment available, but also providing more resources courts can offer. Class B misdemeanor, when the most punishment you can give is up to 180 days in jail, with most jails being full and offering good time credit. There's not a lot of reason for an offender to take probation, take some sort of rehabilitative treatment when they know they'll be done with their jail time in a very short amount of time, and the next time they do it, they'll be facing the exact same punishment. It's for that reason we think this is an appropriate remedy to target those who are committing this sex crime, and I'll be happy to take any questions.
Jacob, thank you very much, and I appreciate it for the members. That was the information that we had talked about, drilling down into that data, that statewide data. So I appreciate you following up and bringing that to us, because it allows us to understand kind of the size of the population. And to Mr. Schaefer's point, we don't like to just ratchet things up just for the hell of it. Like, we want to know, what are we talking about? How many people are we interacting with? And so I think that would be very helpful in guiding our decision-making here. Members, do you have any questions? No? Thank you. All right. Chair calls Judge Jason Ellis.
Thank you, Mr. Speaker, members of the committee. It's a pleasure speaking to you this morning. It's still morning, about afternoon now. But I would echo what we did. I'd echo what Representative Schaefer said and District Attorney Jacob Putman said. There is a class of criminal that commits this crime.
Judge, let me do this before you comment. If you state your name, whom you represent, and your position on the bill.
Got ahead of myself. Yeah, I'm Jason Ellis. I'm judge of the County Court of Law in Smith County, Texas. I'm serving my third term there. And I come to speak to you in favor of the bill.
Perfect. Thank you, Judge.
Thank you. As I was saying, there is a class of criminal that commits this crime and commits it again and again. I think District Attorney Putman has spoken about the data behind it. From what I've observed from the bench, it seems it's almost the rule, not the exception, that folks that commit this crime have committed it before or will commit it again. I could tell you in the abstract, there's something awkward and even almost comical about this crime. I recognize that. But I would tell you in court, when victims testify, they genuinely are traumatized. First of all, when it happens, when someone exposes themselves to them in a sexual way, they don't know that that's where it's going to end. I find that the young women who testify are embarrassed to be in court. They're ashamed to be associated with the act. They didn't know at the time they weren't going to be victims of greater assault. They often flee, lock themselves behind a door somewhere. One young lady who was a member of a local junior college in our community would never walk across the campus anymore after she'd suffered this multiple times without being on the phone with her parents. She eventually left our community. That defendant, and this brings me to the next issue, as a judge, I've struggled with the right punishment to offer when it's repeat offense. I've even taken the worst offenders and I put them on probation, thinking, well, perhaps I can keep tabs on them and require treatment. But without much threat of jail time hanging above their heads, there's little reason for them to comply with the treatment. And when I sentenced them to jail, again, that sentence is served quickly. Another young lady who was a victim of this offense she decided to stop visiting her paralyzed brother in his apartment complex where she took care of him because the defendant still lived there and she was afraid to go there. I don't think there are a lot of defendants that commit this crime, but the ones that do seem to commit it again and again. I think with greater punishment, it would be prohibited from committing the crime, at least for a longer period of time. There'd be greater deterrence. And more than that, especially as it increased the felony range, the courts have more resources at that level, can have longer probations, and I think can affect real treatment, hopefully, of this offense. So thank you for the opportunity to speak to you. I'll take any questions if you have any.
Judge, thank you very much. Members, do we have questions for the judge? No? All right, thank you very much. Is there anyone else wishing to testify on, for, or against HB 1730 at this time? Chair sees none. Recognize Mr. Schaefer to close on the measure.
Thank you, Mr. Chairman, members. There was one other additional story that I thought was worth mentioning where a repeat offender in our community actually had an elaborate plan, traveled to another city to a gym at a peak time of day and, did his thing at a gym. He'd done it before. And so this is an issue. And I think in the internet age and what some men are being exposed to, there's just their minds are warped. And we need an additional tool in our criminal justice system to give them some deterrent, but as the gentleman just said, a chance for the court to provide some classes, some services to maybe get them back on the right track. So, barring any questions, Mr. Chairman, that's all I've got.
I appreciate it, Mr. Schaefer, and I know that you do pause when you look at enhancements and penalty ratchet ups. That's something that you do look at pretty closely, and so you're not bringing this to us, without having done your research on it. So I appreciate that. Members, do we have any questions? No? All right.
Thank you.
Thank you. Okay. Is there, if there's no objection, HB 1730 be left pending. Is there any objection? Chair hears none. HB 1730 is left pending at this time. Yeah, but he's got 3. Chair lays out House Bill 1715 and recognizes Mr. Canales to explain the measure.
Thank you, Chairman, Vice Chair, members of the committee. It's a simple bill. Basically, a criminal record can severely limit the future of any individual in the state of Texas. For example, a college student is caught with a small amount of marijuana, placed on deferred adjudication, although they don't get a conviction. That deferred adjudication is not able to be removed. And so you've got defense attorneys that will tell somebody, oh, you won't be convicted. Unfortunately, you've got a scarlet letter because that deferred is going to be on your record for the rest of your life. And it's assumed, and it's true, that you would have pled guilty in order to get that. So anybody that sees it knows you pled guilty. And so what this bill does is basically say, for certain offenses, nonviolent crimes, if you have a deferred adjudication, and 5 years after that, you've got no crimes whatsoever, it's kind of like a secondary probation, you're able to expunge that record. This bill has been voted out of this committee, I think, every time I've ever presented it. It's actually got passed out of the House with only 3 no votes. It's a common sense bill that removes the scarlet letter on people for nonviolent misdemeanors, allows them to get back into the workforce, improves the Texas economy. And if you've got any questions, I'm standing for them.
Members, have questions for Mr. Canales? Nope. All right.
I close.
Stay close to the microphone. 1 second. Is there anyone wishing to testify on, for, or against House Bill?
I forgot about that part.
What's it?
I forgot about the witness part.
Yeah. Well, you're so convincing, you don't really need them.
I'm a little out of practice.
Anyone else wishing, or anybody wishing to testify on, for, or against House Bill 1715 at this time? Chair sees none, and so I recognize Mr. Canales to close on the measure.
I close.
Right. Thank you. Thank you, sir. If there's no objection, House Bill 1715 will be left pending at this time. Is there any objection? The chair hears none, and House Bill 1715 is left pending. Chair lays out House Bill 1207 and recognizes Mr. Guillen to explain the measure.
Thank you, Mr. Chairman. Members, the statute of limitations for tampering with a human corpse or corroborating evidence in a criminal homicide is not specifically listed in Chapter 12 of the Code of Criminal Procedure. Because of this, the statute of limitations for removing, disposing, dismembering a body or destroying evidence is only 3 years. Concerns have been raised by law enforcement and prosecutors that in cold case murders, the person that helped in the cover-up is not able to be charged with tampering with evidence because the statute of limitations has run out. House Bill 1207 simply removes the statute of limitations for tampering with evidence when that evidence is a human corpse or would be used in a criminal homicide investigation. The bill will ensure that those who help cover up such heinous acts will be brought to justice, no matter how long it takes to discover their actions. I can help answer any questions if you have, and I think we've got somebody here to testify.
You do have a couple of folks. Members, do we have questions for Mr. Guillen? No? All right. We'll get back to you just in a second. Chair calls Detective Mary Lewis. you start your testimony, just let us know who you are for the record, whom you represent, if it's someone other than yourself, and then your position for, on, or against the bill.
Great. My name is Mary Lewis. I'm testifying on behalf of the Williamson County Sheriff's Office and testifying in support of House Bill 1207.
Fantastic.
And I'm a reserve detective with the Williamson County Sheriff's Office Cold Case Unit and a retired special agent in charge with the United States Department of Agriculture, Office of Inspector General. As you know, many cold case homicides are not solved or adjudicated for 20 or 30 years. Under the current statute of limitations, if law enforcement found evidence that a person tampered with physical evidence, including moving a corpse, over 3 years ago, that person cannot be charged with that offense. Oftentimes, there is enough evidence to prove someone tampered with physical evidence, such as destroying a cell phone, disposing of a murder weapon, cleaning up a bloody crime scene, or moving a dead body, but not enough evidence to prove murder. That initial charge of tampering with physical evidence could lead law enforcement to evidence that could prove who murdered the victim. It would be an injustice to the families of the victims and the community if a suspect could not be charged with tampering with physical evidence, to include moving a corpse, because the statute of limitations has run, especially if that is the only violation of law that could be proven in the case. There is no statute of limitations on murder, so there should not be a statute of limitations on tampering with related evidence. I cannot discuss any open investigations at this time, but changing this statute will have an enormous impact on cold and current murder cases across the state of Texas. Changing this statute could result in more murders being solved and justice for families who are grieving for their loved ones who were killed. I'll take any questions at this time.
Detective, thank you very much. Members, do we have questions? And I know you can't discuss particulars of ongoing investigations, who wouldn't ask those questions, but in your conversations with maybe counterparts in other counties, is this something that you've heard echoed from other sheriff's departments?
Yes, I have.
Okay. For similar reasons that you stated?
Yes.
All right. Thank you, Detective. I appreciate your time.
Thank you.
Chair calls Dallas Reed.
Mr. Chairman, members.
Sir.
So my name is Dallas Reed. I am here to testify in support of the bill. I represent the Texas Municipal Police Association. As the state's largest association that represents law enforcement, we're here. This is a very good bill, very simple bill, and I thank the chairman for filing it for us. To underscore what our previous witness said, right now, you can actually help someone remove a body, dismember a body, and if you wait 3 years, there's nothing law enforcement can do. So this bill would simply remove that statute of limitations and allow us to help catch some more of the bad guys.
Dallas, thanks so much. I appreciate it. Let's make sure nobody has any questions for you. Appreciate it.
Thank you, sir.
Chair calls Detective Gary Sweet.
My name is Gary Sweet. I'm representing the Texas Municipal Police Officers Association, and I am in favor of the bill. In my experience, 38 years, the last 25 years I spent working homicides and cold case homicides. The hardest part of my job was dealing with the victims' families and the grief that they went through. I learned that this was something that would never go away, and in dealing with cold cases, that it not only was the grief, it may have been worse because of the lack of justice or the lack of just knowing what happened. Murder is the one crime that there's no restitution can be made. We can't ever bring that victim back. So all they really have is justice. They want someone caught and prosecuted for it. I'd like to use an example of a child serial killer case I worked. It was a cold case. It involved 3 murdered children in the 1980s in the Dallas Metroplex area. This investigation, the suspect in the case was in prison in Ohio for 2 other child murders. He had bragged to other inmates that he had killed as many as 50 kids across the nation, I'm sorry, not the state. But he told us during an interview with him that, I know you don't have any physical evidence against me. I'm sorry. He said, because all I ever had to do was call my mother, and she would go destroy any evidence that you ever could have. He says, there's nothing out there that you have on me. We didn't have enough to build a circumstantial case, and he did plead guilty to these cases. But the fact that there's possibly 50 other cases out there that we may never, ever find out about, and his mother, there's no consequences for her actions, this is a hard pill to swallow for some of these victims' families. And I ask that you pass this for the victims' families.
Thank you, Detective. Appreciate your testimony. Members, do you have questions at this time? No? Thank you, sir. Is there anyone else wishing to testify on, for, or against House Bill 1207 at this time? Chair sees none. Recognize Mr. Guillen to close on the measure.
Thank you, Mr. Chairman. This bill passed unanimously out of this committee last session and out of the House, but it got to the Senate late, and so hopefully we can get it there sooner this year. And I just ask for your, if there's no further questions, I ask for your favorable consideration.
Thank you, Mr. Guillen.
Thank you.
We'll try to give the Senate more time to consider this. They usually move so quickly, though. Members, if there's no objection, HB 1207 will be left pending. Is there any objection? The chair hears none, and HB 1207 is left pending at this time. Chair lays out House Bill 937 and recognizes Mr. Dutton to explain the measure. Let the record reflect that Mr. Bojani has joined us now.
Thank you. Thank you, Mr. Chairman and members. Thank you for hearing House Bill 937. One of the things this bill tries to do is just straighten out the relationship. And let me describe it this way. When a person is in prison, if they, for some reason, pick up a criminal offense in prison, typically it's what we used to do around here. And I know you'll understand this, Chairman Leach. We used to, if you had to appeal a state agency action at one time, you had to appeal it to the state agency. The agency that had already denied you whatever it is, and so that's the only way you could do it. Well, the same thing happens now in prisons. If you have an offense there, you have to appeal it, you have to hear it at the state level to the prison where you are, and that's how it gets there. Well, what this bill does, this bill creates a whole new way in which for offenders to have at least redress a problem that they have in the system. The other thing is, it doesn't say that in a bill, but one of the things we did in my committee is we added a provision that allowed for men in prison who didn't have other resources to actually suspend their child support. If they didn't have other resources, they could suspend it. Well, what happens, Hope? That means he has to file this and that, and I know Representative Cook understands this, that they have to file modifications in order to do that. Well, most of them don't know. I mean, if you're looking at 15 years, you don't file anything. You just look at the calendar is what you do, and that's about all that happens. Well, essentially what this does is creates a state agency to add to make sure that we address many of these ills that are taking place within the system, and that's really all the bill does. It's a bill that we had last session that I don't think it got out of this committee, but it was heard, but we got caught up in a number of things, so nothing happened.
I don't believe that you got caught up in anything, Mr. Dutton.
Well, we were dodging bullets, okay? How about that?
Yes, sir.
Yeah, so I'll be happy to answer any questions to the extent there are any questions.
Members, do you have questions for Mr. Dutton? No? You do have some witnesses to testify as well. Thank you. Chair calls Charlie Maloof. And if we just want to remember, we're going to, if you state your name, whom you represent, if it's someone other than yourself, and then your position on, for, or against the bill.
Yes, sir. Good morning, Mr. Chairman, Mr. Vice Chairman, and distinguished members of the committee. My name is Charlie Maloff. I'm the acting vice president and here representing Texas Cure, and we are for House Bill 937.
Thank you, sir.
The need for an effective inmate legal services office is something that has been lacking for years. The State Council for Offenders is inadequate, and when it comes to major due process cases for prisoners, About 1 in every 10 letters I've received over the last 4.5 years is a request for legal assistance to fight major disciplinary cases where they lost parole, and in some cases facing free roll charges for bogus cases where the inmate stated they were set up by the staff but denied access to DNA, drug, or urine test results, video evidence, and witnesses. Some of them were facing civil commitment upon discharge of their sentence, and some were told flat out it was because the warden did not like them because they challenged him and they were going to make an example out of them. Many were denied assistance by the State Council for Offenders. Unfortunately, most wanted pro bono services because they were indigent and could not afford an attorney. One common problem is what we call the goon squad problem. An inmate makes parole or is under review or soon to be discharged. Guards and supervisors who do not like that prisoner formulate a goon squad and shake down the prisoner, conveniently finding cigarettes, K2, cell phones, or other contraband that lead to denial of parole or free roll charges. Many of these inmates request testing per policy. Many tests are refused, or the testing policy for a second verification is denied. Request to preserve video evidence is denied, and the video evidence is then destroyed after 21 days. There are 97 veterans currently enrolled in the civil commitment program out of a total of 437 residents, for lack of a better term. That is almost 1/4 of the program population, and that alone should raise flags. According to Marcia McLean, Director for the Texas Civil Commitment Office, in her testimony on March 8th in corrections, TDCJ identifies inmates with 2 or more sex offenders. What she did not say was if any of those sex offenses, if caught, were generated for situations like masturbation, which policy says you can be charged with a sex offense if caught. She stated when an inmate is given parole and placed in the 18-month program, that triggers this commitment process by TDCJ. Once a prisoner is identified as a candidate, they are evaluated by TDCJ for behavior abnormality. The problem here is, in the circumstances identified above, if there is a bogus case or retaliation involved and the prisoner is actually innocent, they will not only plead not guilty, but continue to maintain their innocence and fight the case every step of the way, to include going to federal court, only to find their case dismissed due to deficient pleadings. In a subsequent conversation with Director McLean shortly after the hearing, I presented this and the probably factual scenario that if I'm being evaluated for behavioral abnormality, then my ongoing protest of my innocence and denial of due process becomes a denial of acceptance of responsibility of my actions and a challenge to authority, even though I'm actually innocent. This presented an issue with her that she said she needed to look into. In many cases, these inmates have done everything to demonstrate their ability to become productive members of society upon release, and that is why they were approved for parole, but with the stipulation that they had to complete this program. The inmates have no idea that this is an automatic trigger to keep them locked up for years to come, even though a jury and a judge gave them a specific number of years on their sentence. Most all veterans, including myself, at certain ranks go to leadership and supervisor's courses. We are all taught rules and regulations and the processes and consequences in dealing with violations of those rules and regulations. These knowledge, skills, and abilities are ingrained in us. It's natural for us when seeing abuses by government employees, prison guards, and administrators to take them to task. It's also natural for us to educate and assist uneducated and those that cannot fend for themselves, such as those who are illiterate. Those that are inmates walk around the TDCJ with targets on their back. Guards in the administration single them out. As prisoners, a significant number qualify as indigent and cannot afford free roll counsel. In respect to civil commitment, the process starts with TDCJ, the institutional division, then through the special prosecution unit, another arm of the TDCJ, it moves to prosecute, along with psychological evaluations by the TDCJ shrinks, and the only defense available to the inmate is the Special Counsel of Offenders, another arm of the TDCJ. So the take here is that it is TDCJ that decides who they want to keep incarcerated for years beyond what a court of law has determined their respective sentence to be. And in cases of parole, someone who has demonstrated their ability to become a productive member of society, and the TDCJ employees, who most live by the old adage, never bite the hand that feeds you, make it happen. So there's a big problem here. This bill is one of the utmost importance in constitutional integrity and fundamental fairness and due process rights of these prisoners, veterans or not. Thank you for this opportunity to present our support of this bill and your consideration, and we hope you move it out of committee.
Thank you, Mr. Maloof. I appreciate your testimony. Members, do we have any questions? No? Thank you, sir. Chair calls Bill Hayburn. All right, Mr. Hayburn, if you can state your name for the record, whom you represent.
You bet. My name is Bill Hayburn. I'm here on behalf of the Texas Criminal Defense Lawyers Association. I'm co-chairman of their Corrections and Parole Committee. I'm joined by other members of our committee. I would like to review with you briefly the handout.
Your position on the bill.
Oh, thank you. We are greatly in favor of this bill being adopted. I might point out, I believe this is the second or third time we've presented to a committee, but we've not made it to the big show yet. I would like to review with you a handout we've brought. The first part of the handout deals with an article that appeared in the Texas Observer. It makes mention of the issue where TDC has control of the public defender service within its bounds. It's kind of the fox guarding the hen house. It has been that way for almost 40 some odd years. I know that because I was one of the first 11 they hired. When I was hired, it didn't take me long to figure out this isn't working. This isn't working. Where you have in the second part of our presentation, a study done by the State Bar of Texas relative to interviewing prosecutors with the prison and public defenders with the prison, including those past and present. We also have some very interesting statistics that came to pass there. I might point out, well, let me get to that point just a minute. Next, we have the 10 principles of a public defender's delivery system as presented by the ABA. I will point out that the current system at TDC violates several of those, particularly the Principle 1, which has to do with independence. The Public Defender Service at TDC is not an independent service. I suggest for you that if it were, there would be much better defense work afforded, there would be broader defense work afforded, and I think there would be some exposure of issues that the public never sees that arise from these situations. Also, number 8, the public defenders at TDC are paid horribly lower than the prosecutors are. They leave that job with some regularity, and where do they go? The good ones go to other very competent public defender services in the state. I myself have hired 2 or 3 in my practice. I stayed in Huntsville after I left the system, and then I moved to Houston, where I've been since that time. And for the last 41 years, I've chaired this committee. Lately, I've had the good fortune of having a co-representative share this duty with me. And, you know, I'm 84. This is the 3rd time I've been here. And I'm going to keep coming, I guess, until we get a bill in. You don't need the fox guarding the hen house. It just doesn't work. Thank you. Inmates don't trust those lawyers, and it could be a much better system if we could separate them. Thank you.
Thank you, Mr. Hayburn. Did we have questions? No? Thank you, sir. Chair calls David O'Neill.
My name is David O'Neill. I'm with the Texas Criminal Defense Lawyers Association, and I'm testifying in support of the bill today. I want to thank you for the opportunity to speak here. After I retired from the United States Marine Corps, I went to work as the director of the Trial Services Program for State Counsel for Offenders. That division represents the inmates that get indicted for offenses alleged to have been committed in prison. I worked there 95 to 2000, but I've kept in touch with State Counsel for Offenders because I have been a chairman or co-chairman for about 15 years for the Texas Criminal Defense Lawyers Association's Corrections and Parole Committee. You have a number of resources before you that we've provided. I think there's 4 items in the packet that we've provided. What I'd like to do is just briefly go through some background to understand why we think there's a conflict here. State Counsel for Offenders comes under the Texas Board of Criminal Justice, and there is a liaison within the Board of Criminal Justice that deals with State Counsel for Offenders, but they're not day-to-day operators. The day-to-day operations occurs within the Texas Department of Criminal Justice. When I started my job, I was in the BOT building up in Huntsville. That's a building where all other TDCJ employees were. State classification was up there, Woody Hayes. We had cubicles that went up about this high. That's the privacy we had with the rest of TDC. That's the kind of mentality that continues to exist. Now, they got moved to separate offices after that, but that's the mentality that we start with. When I started, what I initially noticed was that the prison system is much like the sheriff. The prison system is responsible for incarceration of the inmates. The sheriff is responsible for incarceration of individuals in his jail. Have you ever heard of a public defender's office being embedded in a county jail system under the sheriff? But that's basically what we have with TDCJ. What are some of the issues that I've seen? Well, when I was the director, I had an attorney trying capital murder cases. I tried to get him CLE, continuing legal education, on how to try a capital murder case. He'd never been to one before. Submitted it, got approved by my boss, the Director of State Counsel for Offenders. You know who disapproved it? The Deputy Director of Texas Criminal Defense, Texas Department of Criminal Justice. Disapproved it. And the attorney had to go on and try capital murder cases without CLE because that's the kind of control they exercise. Now, I've left and there's been a lot of different examples. My question, though, is why does this even happen? Why is it embedded there? And I had the good fortune of presenting as a witness in court one day, Bill White, a former director of the State Counsel for Offenders. And he was the director under George Beto. And I asked him, why is the system set up this way? You know what his response was under oath in Conroe, Texas? Well, I spoke to George Beto about that one day. You know what he told me? So we can control them. And that's what they've been doing. The other examples that have occurred since I've left have been numerous. Right after I left, the Office of Inspector General, who's the investigative arm for TDCJ, they were moved into the building when State Counsel finally got moved to their own building. OIG was moved in there with them. They were moved in there to investigate them. One of them actually conducted a disciplinary hearing on an attorney, a State Counsel for Offenders attorney. That's the problem with the system. Right now, at least the last time I spoke, the IT people for TDCJ would get the computers from State Counsel for Offenders attorneys if there were issues. Can you imagine if you had a loved one in a county jail and they were going up for a trial and the attorney had to turn their computer on over? And that's not the first time this thing has happened. Attorneys for State Counsel for Offenders at one point, before they could shred their confidential documents, had them put them in a box that OIG could inspect before they could be shredded, because OIG was investigating State Counsel for Offenders. That's the investigative arm of the Texas Department of Criminal Justice, investigating the attorneys who represent those inmates. Thank you very much.
Thank you. Let's see. Chair calls Gene Anthus.
Good afternoon, Chairman.
Good afternoon.
Members, thank you for hearing me. My name is Gene Anthus. I'm here on behalf of the Texas Criminal Defense Lawyers Association, where I also am co-chair of the Corrections and Parole Committee. I'm here to speak in favor of House Bill 937. I'm a criminal defense practitioner here in Austin. I've been doing it for almost 20 years now. My practice focuses on criminal defense work in Central Texas as well as parole issues statewide. And I've handled many civil commitment cases and tried civil commitment cases, so I've got a unique nature in that I'm coming to you speaking in favor of this bill as a criminal defense practitioner who is independent and who can testify about how important it is to have independent and adequate representation. The current counsel for offenders does nothing but establish an illusion of representation. Their office generally represents inmates who were charged with crimes while in prison and that are subject to civil commitment after they've been found to be a sexually violent offender. That office, as you've heard before, falls under the purview of TDCJ. The new bill will establish an independent board, an independent office that will actually represent these inmates separate from the current state counsel for offenders. Since the current office is not independent, the attorneys who are hardworking and underpaid are often hamstrung by politics. Defense attorneys, we often have to think outside of the box. And when our hands get slapped by supervisors who are telling us who we can subpoena, what motions we can file, we're not doing our job. It isn't possible if you're essentially threatened with unemployment by your supervisors to adequately represent your clients. Speaking a little bit on the civil commitment issue, an independent office is clearly needed here. I tried a case 3 months ago, one county north of here in Williamson County. That case alone had over 4,000 pages of documents that I reviewed. Luckily, the offender had family that could hire an independent counsel like myself and hire expert witnesses. From dealing with the special prosecutor's office, who is also under the purview of TDCJ, it was very unusual for there to be independent counsel on one of those civil commitment cases. And a case like that takes months and months of work. It's an expedited case. I can't tell you the amount of preparation that goes into that and how important it is to have independent counsel who can advise your client. The other issue I think that's important to note is in the report that you've got in front of you, it talks about the fact that under the current setup, under the State Counsel for Offenders, inmates and clients are not appointed somebody until either they're indicted for an offense, that is, maybe they've picked up a new offense while they're in jail, like a cell phone case, and they're actually indicted for a felony offense, or until a civil petition for civil commitment has actually been filed. I can tell you in my personal practice, when I'm hired on a case, how important it is to get out ahead of cases. It both saves the county money, because I can talk to a prosecutor before it's even presented to a grand jury. It saves the state money in its form of punishment, and it saves my client time and money as well. This bill, by establishing an actual independent office, can hopefully give lawyers the tools that they need so that they can adequately represent their clients and do away with the illusion of that representation. And I urge you to vote it out in favor of that bill. Thank you very much for your time. Questions?
Members, do we have questions for Mr. Hampton? No. Thank you, sir. Chair calls Rebecca Chin. Thank you. Welcome.
Hi, good afternoon, Chairman Moody. I guess no vice chair. Members.
I'll be back shortly.
My name is Rebecca Chin, and I'm the Acting Director of State Counsel for Offenders, as well as the Chief of the Civil Defense Section. And I'm here as a resource witness. I don't have a in favor or not in favor of the bill, but I'm here to give you an overview of our office or answer questions regarding House Bill 937. Essentially, we're a public defender's office for inmates, and we do not give an illusion of representation. We represent indigent inmates who are housed in TDCJ. We have 4 divisions. We have a criminal defense division who operates under Code of Criminal Procedure, Section 26.051. We represent inmates who are accused of committing any kind of violation of the penal code. So we don't represent them on disciplinaries or any kind of free world, which is something out here, any kind of offense stemming from something that happened in the free world. It's specifically related to something that happened in the prison, like cell phone possession, K2, assault, up to murder that doesn't include the death penalty. Our civil defense section represents inmates who have 2 or more sexually violent offenses that they committed either in the free world or in prison, as long as it's defined by the Health and Safety Code. And they get flagged if they have 2 or more of those, and a psychologist determines that they have a behavior abnormality that makes them likely to engage in a predatory act of sexual violence. If that is referred to a district attorney's county and they want to proceed with the case, a petition is filed civilly and our office is notified and we represent them. An allegation is made that they're a sexually violent predator and we represent them on the case. We have an appellate section who handles appeals stemming from our civil cases and our criminal cases. And we have a legal services section who answers thousands of letters from inmates. They handle immigration cases and they handle the biennial reviews of our civil cases. So we directly report to the Board of Criminal Justice. We are not affiliated with the Texas Department of Criminal Justice in any of our daily runnings. There's absolutely no interference with our office since I've been here, and I've been here since 2010, so 13 years, from the Texas Department of Criminal Justice. We run like any law office runs. The director is in charge of the law office and how it runs. And we answer to the same bar as any other attorney in the state of Texas. I think they were saying that an executive director for TDCJ told them that they couldn't go to a CLE. That doesn't happen now. I think you've heard some historical evidence that in the past it may have. I think in the past it was called the Prison Legal Defense, and they actually worked on the prisons at times too. We have an independent office. Our headquarters is in Conroe. We do not, I'm sorry.
That's okay. Go ahead and finish your thought.
We don't turn over computers to IT if they remote into our laptops. It's only to fix something. They do not have access to our personal files. We have never, in my experience, had OIG investigate our shred for personal documents. That would be horrible, and I would turn in my bar card before I let someone do that. And I don't know who's been threatened with unemployment, who's been told not to subpoena someone, or who's been told what motions not to file. So the study, I would like to draw your attention to the dates on the study you were provided. It was from 2018, January 2018, when that was published. And so that is also historical. I think it represents a subset of maybe 30 to 40 people who were interviewed, mostly former employees. And I believe it's not sponsored by the State Bar. I believe there's this disclaimer at the top of it where it's specifically not sponsored by the State Bar. So I'm here to answer questions. As a resource, I'm happy to do that if you have any questions for me.
No, I certainly appreciate you weighing in. Now I know you said that these things aren't occurring in your experience. Do you envision there being any, in the way the system's set up now, is there anything that could be improved so that there isn't even an appearance that there could be some interference with the agency in the work that you're doing and representing your clients? What can be done? That's what I'm hearing is there's a tension there, at least, and I don't know the facts of all these cases, but at least, maybe there's something just naturally that we see as a tension. Is there something we can do to help with that?
Yes, and there is a tension there. And I know that whenever these started the hearings in 2019, our director was aware of this tension, and she worked really hard to even make it more separate. And, one of the things is moving our headquarters to Conroe, where we're not even in Huntsville. We're not associated with that kind of stuff. We have a satellite there, but our headquarters is in Huntsville, in Conroe. She's done a lot more to separate us. She did a lot more to separate us, and we're still moving into more separation. So to keep it more independent and to avoid any kind of appearance of impropriety. For example, like for budgetary stuff, for anything that has to do with raises, it's done all through the chairman of the Board of Criminal Justice. The Texas Department of Criminal Justice is basically, our salaries and our money funnels through them. So basically it's a rubber stamp where they don't have any say in what we do. And that's all stuff that she established while she was the director. And just, I'm sure there is more that could be done, but she accomplished a great bit while she was the director to move us even further from looking like there was any appearance of impropriety.
No, I appreciate that, and I certainly hope that you keep, you kind of keep thinking through that process and ways to improve it, and if there are ideas like that, I certainly would entertain those conversations too. But members, do we have any other questions? Yes, Mr. Darby.
Thank you. Ms. Chen, is that
Yes,
right?
sir.
Okay. Well, I've been around a while, but this is the first I've been exposed to the SCFO. So I've got a couple questions. I noticed in this report that the budget back in 2011, 12, 13, 14, 15 is about $3,300,000 a year. What is your budget request for this budget cycle?
I think this budget cycle is around 3.5 million, still somewhere right there, a little bit more.
So since 2011, you've been operating on about $3.5 million a year.
If I'm correct.
Without increases. How many employees do you have?
We currently have room for 58 total employees.
So you have FTE allocation of 58. How many are non-attorney and how many are attorney?
30 total attorney employees and asked me to do math, 28 non-attorney.
Now, the 30 attorneys, are these full-time attorneys?
Yes, sir.
Their only source of revenue comes from your organization, correct?
Yes, sir.
So we've got 58 people operating full-time under a budget of less than $3.5 million. Okay. Now, you just mentioned and elaborate on the fact that the director of TDCJ does not have any direct oversight or responsibility. The budget, I understand, comes through TDCJ, but they don't actually have any control over that money. It comes under the purview of your department, correct?
Correct.
So it's kind of like the Office of Public Counsel and Insurance. I mean, you're a separate division. So the criticism that says you're operating under the purview and control of TDCJ may not be a fair characterization. You sound like you're operating independently, even though the budget comes under TDCJ. They don't have any actual control over that. Does your director, is she the one that actually asked for the budget appropriation?
Yes, and that's what I'm acting director right now and our former director.
Okay.
Yes, yes, and that's our director's position.
So the current budget cycle, you've made a budget request for your agency
Yes,
to operate under for the next budget cycle.
correct.
Okay. Do you have any direction or input from TDCJ about your budget request or control over the money that you get?
No, and like I was telling them, the chairman of the Board of Criminal Justice, if there's anything regarding budget, that's who we go to, and there's no affiliation with the Texas Department of Criminal Justice.
Well, can he direct or control your expenditure of funds?
I don't believe so.
So you have total purview with legislative oversight through the LBB and through the budget process, correct?
Yes.
So the idea in this legislation that we're going to create a new board, we're going to hire another director, we're going to give more money to lawyers, your lawyers, and all of it has a zero fiscal impact to the state? That's what I'm looking at. The fiscal implication of this bill to the state is no significant impact.
Yes, and in full disclosure, we do share resources with the Texas Department of Criminal Justice. I don't want to mislead you. One thing we do, we share a motor pool. So we do drive cars from the Texas Department of Criminal Justice.
You do?
We do drive cars, like we share cars.
Oh, you share cars?
We do share cars, and we do have office equipment and things like that. So I don't want to say that we are independent, like, I don't want to give you that impression. So we do share resources, and,
But you moved to Conroe.
yes, sir.
Okay. If the whole purpose is to create this independence, sounds like you're pretty independent right now.
We believe so.
Are you sensitive to the fact that your lawyers are making less than the prosecutors?
We are.
What are you doing about that?
It was last year or the year before, one of our sections, we approached the chairman and secured raises for one particular section because we weren't able to employ attorneys. It was the civil defense section because of the vast amount of travel that occurred in that section. And one of the goals that we do have is to try to secure similar raises. I can't guarantee that it's going to happen, but we are sensitive to the fact that we don't have the parity in pay, and that's one thing that we are sensitive to and want to accomplish eventually.
What kind of workload do you have on your 30 attorneys?
We have in the criminal section, our attorneys, it's 410 cases total between.
Total?
Yes, sir. For the entire section between, I have that right here. Between 5 attorneys, full-time attorneys.
Are doing 410 cases?
Yes, and that's anywhere from possession of cell phone in K2 up to assault cases mostly.
And that's a year?
It's at this current time.
From January to March?
Yes, sir. Or that's their current caseload as of last Friday.
What kind of caseload do they have on an annualized basis?
On an annual?
Annualized basis.
I would have to get you those numbers, and I can do that.
Okay. What are your performance metrics that the OBB has established for your budget?
That I would have to get you to.
Okay.
But I can tell you that for our civil division, right now, we have a caseload of 57, and each attorney has 10 or 9, because all those cases go to trial. That's the current caseload. Each year, we have approximately, it depends on how many cases are filed, but there's approximately 50 cases that are tried a year. For our legal services division, right now, they currently, I don't have specific caseloads for them because it's kind of, they read the letters. There's letters that come in that they respond to from inmates, and they have the biennial caseload. But our appellate caseload has 56 appeals right now, and they have it split between the 4 of them.
Have you looked at the legislation?
Yes, sir.
Talks about the board determining the director's compensation, and then the board determines the compensation of the office employees and the attorneys. Currently, you do all that now. Currently,
Board,
you
yes.
do all that now.
Yes.
Thank you.
Thank you.
Could you do us a favor when you follow up with those, if you could follow up with everybody on the committee so they could have that information as well?
Absolutely,
I think
yes.
that'd be helpful to us as we kind of evaluate these things. Members, do you have any other questions? No, thank you for your time.
Okay, well, thank you.
Appreciate that. Is there anyone else wishing to testify on, for, or against House Bill 937 at this time? Chair sees none. Recognize Mr. Dutton to close on the measure.
Thank you, Mr. Chairman. Thank you for your question, Representative Darby, and thank you for the questions. You know, in my almost 40 years of practicing law, in the criminal justice area, that's the one area where a perceived conflict of interest is just as bad as an actual conflict of interest. Think about it. We do lots of things to eliminate even perceived conflicts of interest in our criminal justice system. But here we are having an agency who wants you to believe that because they moved to Conroe, but they used the vehicles from TDCJ but they actually move the road, there's no conflict of interest. Maybe that's true. I'm not certain whether that's true, and that's not my argument. My argument is simply that we ought to eliminate even the perceived conflict of interest. And that could be done very easily by simply adopting House Bill 937 so that, because unfortunately, there's nobody going to come here, really, we're not going to have the people who are really the beneficiaries of the system come here and testify because they're locked up. So they can't come here and testify. But I would almost be willing to bet you that if you talk to every one of them, you'd get 100% objection to the last testimony that you heard. You'd get probably 100% objection as to whether or not they should have an independent agency helping direct what happens to them in TDCJ. Finally, Mr. Chairman and members, how we treat people in prison says more about us than it does about them. And with that, I close.
Mr. Dutton, thank you. I think that's a very true statement. Do you have any questions for Mr. Dutton? Did you? Okay. Thank you.
Mr. Chairman.
Members, if there's no objection, House Bill 937 will be left pending. Is there objection? The chair hears none. House Bill 937 is left pending at this time. Chair lays out House Bill 1347 by Mr. Dutton and recognizes Mr. Dutton to explain the measure.
Thank you, Mr. Chairman. This is another non-controversial bill.
I've heard it a couple of times.
Well, let me thank you, Mr. Chairman and members, for hearing this bill. I was never so, I only tried a few of these cases, but the first one I tried on resisting arrest, I went back to talk to the jury. The jury found my client not guilty. And I went back to talk to the jury after to tell them thank you. But the first question they asked me was, what was he being arrested for in the first place? I said, I don't know. They said, well, we wanted to know that. I said, but the law doesn't require that that's a part of the charge, why you were being arrested in the first place. And so as a consequence, what happens is the courts have kind of made this a little bit muddy too, because what the court said in a case was, if the police officer just happens to grab you by your arm and says, you're under arrest, and you pull away and say, well, what am I being arrested for? He then changes it to resisting arrest. There's a case that stands for the proposition that the law enforcement arrested a lady and they put her in the backseat of the car. She kicked at the police officer and missed. That was deemed resisting arrest. And so what this bill does is simply doesn't do away with resisting arrest. It just says that when we have a charge of resisting arrest, one of the things we'll include in that charge is why the person was being arrested in the first instance. And that's all it does. I don't think you'll hear a lot of law enforcement being in favor of this bill, and I will tell you that. It is, and I do have several law enforcement friends who I talk to at different times, and, and they'll tell me that, well, Harold, that's kind of sometimes our fallback position. If you can't arrest them for anything else, you can arrest them for resisting arrest. And when you get to court, what happens is, in a lot of instances, many instances, and I don't have the numbers, but there's a significant number of arrests, for example, in Harris County, for just resisting arrest. And yet most of those people, almost to a T, do not know why they were being arrested in the first place. That resulted in the charge. So anyway, that's what this bill does, and I'll be happy to answer any questions, Mr. Chairman and members.
And to be clear, so 3803 includes arrest, search, and transportation.
Right.
The bill that you're bringing today would only create this obligation if the allegation was resisting arrest.
Exactly.
Right.
Where that is the only charge in the information or in indictment. It would be only that.
Got it. And doesn't do anything to change 3803B, which says you don't get a defense to prosecution if the arrest or search was unlawful.
But that's right. It doesn't change that at all.
And that is, and we can talk about the policy underlying that, but you want people
That's not
ultimately to
the bill.
comply, but you don't even touch that here.
No.
Right, and so we're not gonna go into that. So
No.
we're not getting into that conversation. We're just saying, good case, good case to give an example. Well, I don't want to use the word good here, but I think I've had a lot of conversations around the case involving Sandra Bland.
Yes.
Right, and people say, well, she was arrested for resisting
Yes.
arrest. And I said, well, what was the initial arrest for? And this led to the conversation about Class C arrest because it was failure to signal a lane change.
Right.
Which is why she was ostensibly why she was being arrested.
Right.
And so that's led to a broader conversation about what we want to have arrest authority for.
Right.
So I think it's an important conversation. Certainly is good information for folks to have. So I appreciate you. I know this conversation.
That's all right. No, but
multiple times we've heard this bill, but I think it's important for us to talk through it.
Well,
because it's a
thank
complicated
you
issue.
for that. Thank you for that, too, because that helps to explain to a lot of the members who aren't necessarily lawyers what happens in these kind of cases and what we're really trying to do with it, because I'm not trying to change in total 3803.
Mr. Carpenter, yes.
Well, I am a lawyer, but I thank you for explaining. So when you say state the underlying offense, they're not, you don't have to justify or prove that.
No,
You just have to state it.
that's exactly right.
Okay, thank you.
It just has to be included why you were being arrested in the first place.
All right. Members, have any other questions for Mr. Dutton? We do have one witness, so just hang tight.
Thank you.
And we will bring you back up to close.
And I started to say, I reserve the right to close, but the rules don't say that. Rules don't say you can reserve the right to close.
That's true. That's been pointed out to us today. So we've been using using verbiage, I guess, that isn't accurate as to the rules. We're going to correct our scripts from now on, Mr. Dutton. We try to follow the rules here. Chair calls Jennifer Szymanski. And I apologize did I pronounce that okay? Oh, thank God. All right. And if
Good afternoon, Chairman and members of the committee, Vice Chair Cook. I'm Jennifer Szymanski, Director of Public Affairs for CLEAT, the Combined Law Enforcement Association of Texas. I'm testifying in opposition to House Bill 1347 on behalf of my organization. The charge referenced in the bill, Penal Code 3803, is titled Resisting Arrest, Search, or Transportation. The charge is independent of any other charge and is a separate offense. The circumstances surrounding any additional charges have no bearing on the resisting charge itself. An underlying charge would only apply to the resisting arrest portion of the statute, and the related information would be part of the probable cause affidavit approved by a judge. The bill does not address how this would be handled for charges that fall under the resisting search or transport portion of the statute. Those two are listed in the same statute and constitute the same charge. A search, for example, does not require an underlying offense. It should also be noted, as it already has been by the chair, that subsection B of the current statute reads that it is not a defense to prosecution that the search or arrest was unlawful. Mm-hmm. Last session in this committee, a witness who testified after I did, who was not employed or affiliated with the Austin Police Department, provided false testimony and statistics related to the number of times this charge was filed inside of the department. Those stats, again, did not differentiate between charges for resisting search or resisting transport or resisting arrest. They were all lumped into one and all categorized as resisting arrest, providing an inaccurate picture of the data for the committee. I guess she's not here today. We are opposed to the bill and would like to reiterate that any detail pertinent or relevant to a resisting charge would be laid out in the probable cause affidavit as it is an element of the existing law, Penal Code 3803, resisting arrest, search, or transportation. That's all I have. Thank you for your time.
I appreciate that, and that was kind of what I was trying to drill down on with Mr. Dutton, since you have 3 different ways under this penal code provision to get after that. Do you think, and is that something that you could work with Mr. Dutton's office on, is if that's really the conduct, that's really the piece of it he's trying to get after, is under the arrest portion. Do you think there are ways, I think the bill attempts to do that, but maybe it's not quite there yet in your opinion. Is there a way we could work on that? Because this is about notice, notice to those that are charged, and that they understand the charges against them. If there is an underlying, they may have that. Sometimes they choose not to charge, like you got a Class C offense, and then, that's the original charge, but it gets wrapped up into something bigger, and you never actually see the other crime come forward. It may be in the probable cause affidavit, but maybe isn't given notice in the charging instrument itself. I don't know what the practice is, if they include the stuff. It's not required to. I guess the bill would make it a requirement. Is that something that y'all can sit down and kind of think through on the arrest portion?
It seems to me that in order to accomplish this, we would have to break the statutes out into 3 statutes: resisting arrest, resisting transport, resisting search, for this to make sense. But like I said, the probable cause affidavit, unless it's sealed, which is rare, would provide this information and discovery. So I don't see, without breaking this down into 3 separate statutes, which the legislature could do, I don't see where this would make sense.
Well, transparency in the criminal justice system is a good thing. And so this is information that would be available to the public, right? The charging instrument. And so that is, I think that's kind of what we're trying to get to, is understanding the charge, and that the public can understand what the charge is. And so that's what I would like to try and drill down on. I'm good, Mr. Dutton, I guess we can work on this, but it'd be helpful if we can get some thoughts on ways to parse that out. And maybe there are jurisdictions that are doing this. I'll visit with some prosecutors about it, see if they do. Like I said, they could choose to do this now if they wanted to. They don't have to, I guess. But maybe we can find out if anybody is doing that in their charging instruments. Are you aware of that anywhere in the jurisdictions that you work in?
I'm not, but I do think that the probable cause affidavit is also available many times to the public if asked for, with maybe some redacted birth dates and information. And I agree with you that transparency is important. And in this case, it's actually been falsified and used inappropriately against law enforcement, as stated, in the previous testimony last session about.
We're in a new session.
Right, but I agree with you on transparency.
Sure.
And I think in this case, again, using data with this particular arrest category, because they are all lumped together, that data is an inaccurate picture of how often resisting arrest is utilized.
Oh, no, and data is a big problem. And we actually explored that during the interim, and what data we're capturing and how we're able to actually disaggregate that. So we're certainly looking at that too, because we need to make sure that we have a clear picture of what's going on, because there's multiple ways that we can get after this. So I appreciate you raising that, because that is certainly an important issue as well. Well, I appreciate you coming to testify.
Thank you.
Members, do you have any other questions? Oh, yes, Mr. Bojan.
Just want to quickly clarify. So you have issue with this bill. You're against it because it's a procedural issue that you have, not substantively. I just want to make sure you're okay with the substance of providing that information to a defendant or to the public.
If required, such as it is in resisting arrest, because it's an element of the actual offense itself, yes, we're fine with that, and we do that every day via the probable cause affidavit.
Got it. Thank you.
Okay. Members, any other questions? No? Thank you so much. Appreciate your time. Is there anyone else wishing to testify on, for, or against House Bill 1347 at this time? Chair sees none and recognizes Mr. Dutton to close on the measure.
Thank you, Mr. Chairman. I was going to just close, but I couldn't let pass the old adage that in law school, that when the law is on your side, argue the law. When the facts are on your side, argue the facts. But when neither is on your side, just keep arguing. And so This was the first for me. This is my 20th session. I've never heard a witness come in and testify on a bill and support that testimony by saying, last session, somebody brought in some statistics and data that wasn't valid. I don't, I hope that doesn't make this bill subject to a point of order, but I don't think anything in the rules support or prohibit that. And then the last point I want to make is this. The witness says that it's discoverable in the probable cause affidavit. Well, what would be wrong with including it in the charge? So I leave that with you, Mr. Chairman, because I think I think you all will do a better job at figuring this all out. So I thank you.
Thank you, Mr. Dutton. I appreciate that. Members, do you have questions for Mr. Dutton before we let him go back to work in public education?
Yeah, exactly.
As Mr. Harrison is doing.
Oh,
No?
thank you.
All right, members, if there's no objection, HB 1347 will be left pending. Is there any objection? The chair hears none. HB 1347 is left pending at this time. I do want to say this just for purposes we kind of get this. You can see people coming and going, including me. I've got a meeting I've got to go take on a bill that we're working on. I'm going to jump out. Mr. Cook's gonna drive or fly the plane for a little bit here. But just know that members coming and going are on other committees, are presenting bills in other committees, have staff meetings, have constituents in from out of town. So there's a lot that we're managing all at one time in session when we're compressed into these longer days. So no sign of disrespect to you, your bill members, or your testimony witnesses. But when you see people coming and going, that's just that's the busyness of session. And apparently someone decided to start session this week. And so we're all kind of running around with what's left of our hair on fire. So, all right, thank you.
All right. Mr. Shaheen, if you're ready, the chair lays out House Bill 1004 and recognizes Representative Sheen to explain the bill.
Thank you, Chair Cook, members. House Bill 1004 seeks to provide better protections for disabled Texans from being victims of human trafficking, including sex trafficking. The bill also increases the penalty if an actor engages a prostitute and the prostitute is found to be a victim of sex trafficking. Similar to children, disabled individuals are especially vulnerable to being victims of human trafficking. According to the National Disability Rights Network, people with disabilities are deliberately targeted and more easily exploited. Despite this fact, if an actor causes a disabled person to engage in prostitution, the hurdle to prosecute the trafficker is the same as a regular adult. The law currently requires proof that a disabled individual was trafficked by force, fraud, or coercion. This hurdle is often difficult with a special needs Texan since they are easily manipulated. They are not able to understand the actions they are performing due to their functional difficulties. Therefore, the disabled need the same protections that we provide children, and that's what HB 1004 does. It provides the same protections to disabled individuals as we currently have for our children by removing the requirements to show force, fraud, and coercion by the human trafficker. It also increases the penalty from a state jail to a second degree if an actor engages a prostitute and the prostitute is found to be a victim of sex trafficking. I do have a witness from the DA's office in Tarrant County that focuses on this, and she'll add some additional context to the proposed legislation. But with that, Chair Cook, I'm happy to answer any questions and reserve the right to close.
What a great decision you made in calling the Tarrant County District Attorney's Office.
Well, she's actually been very helpful with us. She's worked quite a bit with us in the interim.
With my office as well. Members, any questions for Mr. Shaheen at this time? All right, thank you, sir.
Thank you, sir.
All right, the chair calls Lindy Borchardt. Mr. Borchardt, if you would, please state your name, who you're here on behalf of, and please state whether you're testifying on, for, or against the bill.
Yes. Chair Cook and members of this committee, I'm Lindy Borchardt. I'm an assistant criminal district attorney in Tarrant County, and on behalf of Phil Sorrells, the criminal district attorney, I support House Bill 1004. I have the privilege of prosecuting human traffickers, and I firmly believe that a measure of our society is how well we protect our most vulnerable. And sadly, today, some of our most vulnerable are our disabled individuals that fall prey to sex traffickers and also criminals who force them to commit prostitution. Disabled individuals cannot protect themselves because of their mental disease and defects. This bill offers that protection that is so important. It's the same protections that we offer to children to help protect them from sex traffickers and those who want them to force them into committing prostitution. This bill removes the showing that a trafficker through force, fraud, or coercion causes the disabled individual to commit prostitution or the other offenses listed in the sex trafficking statute and also in the statute where they are forced to commit prostitution. And what does that mean? A couple years ago, I had a case with what I believe to be a disabled individual. She was 19 years old and very low functioning, and she was being forced into sex trafficking by a defendant. Thankfully, I should say, at times she was forced into committing prostitution. Had she not been forced, then I would not have a case. That's important because disabled individuals, just like children, don't have the abilities to protect themselves. It does not require force, fraud, or coercion by a sex trafficker to traffic these disabled individuals. It might be as simple as telling a disabled individual, I want you to go perform oral sex on that John and get paid and bring the money to me. And she would comply. Because of her mental disease and defect, she can't protect herself. In that situation, under the current law, I would not be able to prosecute that sex trafficker. And that is simply wrong. This bill provides the protection that we need for disabled individuals. It's consistent with the law and how we protect children also. Do you have any questions?
Any questions for Mrs. Borchardt? Mr. Harrison.
Thank you, Mr. Chairman, and thank you very much for what you do on a daily basis to go after the scourge, the evil that is human trafficking. Quick question on clarification, because I do want to make sure our state criminal statutes give you all the tools you need to go after human traffickers. This section on Part 4, Section 4 on page 2, is it a potential unintended consequence of the statute that somebody who's being charged and then prosecuted for the crime of prostitution, could this lead to a great variance in penalties for the same crime, just committed by different people, if they happen to have solicited or engaged with somebody who happened to have been trafficked without their knowledge?
Great question. So solicitation of prostitution, as you know, last session was increased to a state jail felony, and that is for an adult. In solicitation of prostitution, the criminal offense there is the agreement to pay for sex, whereas in your sex trafficking statute, the third way to commit sex trafficking is if you engage in sexual conduct with a person who has been trafficked. And so sexual conduct is sexual intercourse, deviant sexual intercourse. So your solicitation cases are for the agreement. I don't have to show that the person actually had to go through with the prostitution and have sex with the John. And so those are the slight differences in those situations. It's the same for children. The solicitation of prostitution includes children, and that's a second-degree felony. And then your trafficking case also includes children, and if they have to perform sexual conduct with who I say is a John, then that is a first-degree felony if that child had been trafficked. Does that answer your question?
It's helpful, and I can perhaps follow up more offline with you on. I'm just looking for to avoid particular situations where defendant or convicted A and convicted B, two individuals convicted of the exact same crime, is there the potential, as drafted, for widely disparate punishments. That's just kind of the question I'm trying to go at.
Right. I don't believe so because the law's already drafted that way for children.
Okay.
And so this just includes the disabled individual. I have not seen that problem when it comes to our children, and so I don't believe it would be a problem with the disabled. But of course, I would be glad to further discuss this with
Look
you at
forward
your
to
convenience.
this and the other issues we've been talking about already. So thank you very much. Thank you, Chairman.
Thank you, I sure do appreciate it. Any other questions?
Any other questions for Ms. Borchardt? All right, thank you for being here today, and thank you for what you do in Tarrant County.
Well, thank you for what y'all do.
All right, is there anyone else here wanting to testify on, for, or against House Bill 1004? Hearing none, Chair recognizes Mr. Shaheen to close on the bill.
Thank you, Mr. Cook and members. I appreciate this opportunity. HB 1004 provides the same protections for our disabled as our children, addresses the demand side of sex trafficking, and I request your favorable consideration. Thank you.
Thank you for bringing House Bill 1004. And members, if there's no objection, House Bill 1004 will be left pending. Is there any objection? Hearing none, House Bill 1004 is left pending. Thank you.
Thank you, members.
And members in the audience, I wanted to let everyone know there's an overflow room in E2010. If you are wanting to have a seat, you're welcome to sit in E2010. Next, Chair calls Mr. Hefner with regard to House Bill 914. The Chair lays out committee substitute for House Bill 914 and recognizes Representative Hefner to explain the bill.
All right, thank you, Mr. Chairman and members. Thank y'all for hearing my bill today. I appreciate what y'all do here. My first term, I served on this committee with Chair Moody as my first chairman, so I know there's a lot of work and a lot of long hours coming your way. The committee substitute for 914 seeks to address the significant issue of fraudulent temporary motor vehicle tags in Texas by giving law enforcement additional clarity and tools to fight back against this criminal behavior. Fraudulent Texas temporary tags are currently being bought and sold on the black market here in Texas. This is a serious public safety issue, as these fraudulent tags are often used to mask more dangerous offenses ranging from stolen vehicles to robberies to kidnapping and narcotics offenses. The committee substitute for 914 would expand the definition of governmental record in the penal code to include a Texas temporary tag. Under current statute, a final conviction for the offense of tampering with a governmental record is a Class A misdemeanor unless the actor's intent is to defraud or harm another, in which event the offense is a state jail felony. This offense would also be included in the list of offenses for which an officer may issue a citation instead of taking the offender before the magistrate. This would have the practical effect of allowing law enforcement to charge a person with tampering with a governmental record when running across an altered temporary tag, which happens pretty frequently according to law enforcement. As the chairman stated, I do have a committee substitute in this bill that makes an adjustment. The original bill would have included an automatic license revocation on final conviction, and all the committee substitute does is remove this section from the bill. After conversations, the reason I did that is there's other crimes that are connected to registration, different things that have an automatic license revocation. I wanted to, my view on this was to see that the criminal penalty is strong and consistent, but I want somebody to, when they're convicted, to serve their time, serve their debt to society, and I want them to be able to get back to work. And to me, revoking their license would make that harder for them to get back to being a productive citizen. So after conversations with law enforcement officers who are seeing these issues firsthand, we believe that this committee substitute for House Bill 914 will build on the successes and progress we've made on temporary tags here in Texas and ultimately make our state safer. So thank you all for your time. I'd be happy to answer any questions if you have any.
Any questions for Representative Hefner? Chair recognizes Representative Darby.
This, from my perspective, this is a huge problem. In fact, my wife and I play games driving down the interstate on which are clearly fraudulent temporary tags and which may have some semblance of authenticity. The proliferation of this malady has to stop, in my opinion. And so are you creating an offense simply for the person who has that fraudulent tag on their car? I mean, for example, is it an offense to say I didn't know it was fraudulent? I just went online and.
So I believe I have a resource witness here that can answer down to that level of technicality.
Okay.
I will tell you, last session, I don't want to go too much into last session or bills that are not before us, but we made some pretty good strides on the dealer side of this, where these tags originate. This is more on the user side, kind of getting it from the back end. And so when we started down this road in 2021, there was a time there where the experts that we were working with, where there was approximately 60,000 fraudulent temporary paper tags, Texas tags, in the state of New York. So they're not only being used in Texas, but they use these to get around in other states and commit crimes and things. And so since we did what we did last session, the Department of Motor Vehicles has gone a long ways, put a lot of checks and balances in place. And so this was in our original bill, and it got taken out over in the Senate. Sometimes they mess things up, believe that or not. And but this just puts that back in there and giving our law enforcement an extra tool in the toolbox.
Good.
Any other questions for Representative Hefner? All right, thank you. We're going to take some testimony now. All right, Chair calls Jose Escribano. Thank you. If you would, please state your name, who you're here on behalf of, and your position on the bill if you're testifying.
I'm Sergeant Jose Escribano, and I am here on behalf of the Constable Precinct Number 3, Travis County, and on behalf, we are supporting House Bill 914, Hefner.
Thank you.
I have another witness behind me that's going to testify also, Deputy Kohler, and he can address other issues too. This bill, what it does for law enforcement, it gives us another tool. It doesn't change tampering with the government record 3710 at all. What it does, it will reinforce a case law, Efrain Nunez-Martinez versus State, where they recognize that a temporary tag or a buyer's tag was in fact a governmental record. All this does is clarifies it for prosecutors that in fact it will be in the bill. Also, it gives law enforcement a very, very important tool. That is that if I stop you and you have an altered tag, which we're seeing, and it's just a tagdemic. And Representative Hefner was absolutely right. I just got back from the border, and I can talk to you about that. I was in Brownsville last week for 4 days. The tags are everywhere. And this, what it does for us is that I can, when I stop an individual, instead of taking him to jail, I can issue him a citation on a Class A. And that gives me an advantage on several points as law enforcement. I don't have to arrest you right there and then, because if I identify you, you have a document that's bad, but we can work with that and prosecutors can work with that. So that gives us an advantage in law enforcement, in my opinion. That's why we wanted to insert that there, so it does not really change 3710 at all. It just gives an explanation as far as the definition of a tag, and then it also gives us the ability to issue a Class A. And I'm open for any questions that you may have.
Any questions for Sergeant Escribano? Thank you, sir. Oh, yes, sir. Chairman Darby.
How do you know, I mean, this is for a tampering with a temporary tag. It has nothing to do with an expired tag.
Correct.
It could be a valid tag. It's just
Correct.
expired
Correct.
time. But do they have to knowingly, I guess I'm going back to, do they have to know that this tag is fraudulent?
Do they have to know? Well, I can go ahead and go, this is, I teach this. You have a case, Samantha Paps versus the state, where the state of Texas went ahead and advised people that are driving a vehicle, if the vehicle is yours, you should know, okay, what you have on your vehicle. Okay, so let's say the vehicle is yours, you go online, you purchase it, you know that you don't get paper tags there, you go to the registration at your county, and people should know this if they're registering their car properly, if you're buying a car. So that is already in place. So all this does, again, is if you know that the vehicle's yours, you put that tag on there, you're tampering, you've in effect have presented it to me as an official government record, because that's what the statute says. 3710 says if you present that to me, that means if it's on your car, you're presenting it to me. So in fact, you are violating the law, but it gives me, let's say, some breathing room. Instead of arresting you right there and then, which we see this all the time, I can issue a Class A and then let the prosecutor and the system deal with it at that point.
Okay, thank you.
And it helps me a lot.
Thank you.
Because again, like I said before, last year alone in the state of Texas, they issued over 9 million paper tags, and also they issued about another 1 million permits, and they also issued probably about 2 or 3 million fraudulent tags on top of that. I've been working on this for the last 5 years. We're still not finished with this. There's more work to be done. And when I went to Brownsville, and I was with Brownsville PD last week, it was horrific.
I guess the question I have is the arrest not more, looks like the arrest would be more, I guess, persuasive than issuing a Class A citation.
I think an arrest would, but there are circumstances. Let me give you an example. Had an individual that I went and stopped, they had 4 kids in the car. Would it be feasible to go ahead and arrest, call CPS, and go through that whole mess, or give me the advantage to go ahead and issue a Class A? I know who you are, and we'll deal with that later. Again, it's a tool. I don't have to do it. It's like, you know, the marijuana charge is the same thing. It's a tool that allows law enforcement, and that's all this is. It changes nothing. It just gives us a tool to continue to do this. As a matter of fact, on my way in here, I had to stop. I mean, it's just so prevalent. It's unbelievable.
It's a big problem. Thank you for being here, and thank you for what you do.
Thank you, sir. Thank you, sir.
Mr. Chairman.
Oh, I'm sorry. We have Mr. Sergeant
Escobar.
Escobar. One more question. Sorry. Ms. Bowers.
Thank you, Chairman Cook. I just want to know, Constable, how long are paper tags allowed?
How long are they allowed? If you purchase a motor vehicle in the state of Texas, a dealer will give you a tag, and it's good for 60 days. The problem that we're having in the state of Texas is that you receive that tag, or the dealer receives that tag in a PDF format that your average 7-year-old with Adobe Pro can alter. But it's good for 60 days. And also you have dealer authorized agent tags. You have also dealer vehicle specific tags. You also have internet down tags. And I can talk about that for a while. I teach a class on it. It's crazy.
Wow. Well, please do come by my office.
Ma'am, anytime. Please call me. I will be more than happy. As a matter of fact, when I have a class, I'll invite you to come to it. Sit through it.
Yes, thank you. And I'll ask my husband too. He sells cars.
Thank you, ma'am.
Thank you.
Thank you, Sergeant.
Thank you.
All right, Chair calls David Kohler. Mr. Kohler, we show you testifying on your own behalf and that you're testifying for the bill.
That is correct. So, good morning. My name is David Kohler. I'm still in law enforcement in Central Texas, going on 32 years now. And I'm here in support of House Bill 914 by Representative Hefner and the amendment that I just found out about, which is a good thing. So the handout that you're getting right now is case law from Efrain Nunez Martinez, who was arrested for altering a temporary tag, 1995. 1999, the Texas Court of Criminal Appeals upheld that conviction and identified a temporary tag as a governmental record. However, the penal code has not caught up yet, and that's why we're here. Again, HB 914 does not create any new statute, does not create any new law, does not create any new penalties. All it does, 2 things, again, is identifies temp tags as a governmental record, and it allows officers the ability or the option to do a cite and release, because not every single person that commits a crime has to physically go to jail that day, but they still have to be held responsible for their actions. And temp tags, even though it's a piece of paper that looks like these altered ones, this one looks like it was used by using a ransom note, putting it together, or this one that is a brand new in the new format version, this is altered, this is fake. They don't have to go to jail, but this is not a victimless crime. Your toll bills go up, your registration goes up. Now we have people that Their temp tags are being copied and running on toll bills, but the owner lives in Florida, and it was a temp tag that they used to have. They've destroyed it. They've re-registered their vehicle in Florida, but somebody else is using that fraudulent temp tag in Dallas in the North Texas Transit Authority area. Again, this is not a victimless crime, paper tags. You can ask the Solberg family of New Braunfels who lost their child, Officer Brandon Sy from Grand Prairie, Sergeant Kayla Sullivan from Nassau Bay, all over paper tags. Again, two things that are important. Identifies tags as a government record, gives law enforcement the option of a cite and release that I don't have to take you to jail, tow your car, call CPS for your kids. And I'm here to answer or try to help answer any questions you might have. Thank you for your time.
Any questions for Mr. Kohler? Okay, right. Chair recognizes Ms. Morales.
I just want to know, why are there so many temporary tags? Like what crimes are, why are people doing this? So, and I see them all over the place as well, so.
We could, again, like Sergeant Escorbano told Representative Bowers, we can talk about this all day. There's all kinds of reasons. Either they don't have the title to the car, they bought it online, who they bought it from doesn't have a title, either they don't have proper registration, they don't have inspection, they don't have proper identification credentials, or a lot of times people just don't care to get their car registered, or they would prefer to use their vehicle in the commission of crimes, whether it's attempted capital murder of a district court judge in Travis County, armed robberies, kidnapping, human trafficking, avoiding toll bills, not paying your registration or inspection fee. The list it's endless. I hope that answered your question.
Chair recognizes Chairman Darby.
Can you give me a copy of what's valid?
Not legally.
What they're supposed to look like?
Oh, what it looks like, what it's
Yeah,
supposed to look
what's
like?
supposed to look like.
I can send that to you.
I'd love to have that, to compare it as we go, as we travel, you know. We can, my wife can, she can have a copy of it and I can look at it, we can compare it to.
And I appreciate somebody else besides myself that plays the paper tag game going down the road. Thank you for doing that.
Okay, thank you.
Any other questions for Mr. Kohler? Thank you, sir. Thanks for being here. All right, is there anyone else that wants to testify on, for, or against House Bill 914? All right, hearing none, the chair recognizes Representative Hefner to close on the bill.
Thank you, Mr. Chairman. I close.
Thank you. All right, the committee substitute for House Bill 914 is withdrawn, and unless there's an objection, House Bill 914 will be left pending. Members, is there an objection? Hearing none, House Bill 914 is left pending. The chair recognizes Representative Smith. On House Bill 1528, chair lays out House Bill 1528 and recognizes Representative Smith to explain the bill.
Thank you, Mr. Chairman. Members, appreciate y'all's time today. Representative Chairman Darby, I'm going to tell your wife you're trying to get the edge on her on this bet you guys have. I probably better not say that before I put this bill out here, though, but I guess it's too late. House Bill 1528 is an omnibus bill to improve our state's indigent defense system. It consists of multiple proposals adopted by the governing board of the Texas Indigent Defense Commission under its authority in the government code to make recommendations to the legislature. The proposals were developed following TIDC's legislative policy, where a diverse stakeholders work group was convened over the summer of 2022 to vet proposals. Proposals supported by the work group were then considered by the TIDC's Policies and Standards Committee and ultimately considered by the full governing board. These are all consensus recommendations and are not expected to at least have too much opposition to them. There will be, you need to know, there will be a committee substitute to this bill. But due to ongoing conversations, some of which occurred actually before I got up to testify, the final language is not available for this hearing today. My plan is to introduce some of the key changes made by the version in front of you and some of the changes currently being discussed for the substitute. The primary provisions of this bill, and there are many, but they are, to summarize, allow managed assigned counsel programs access to DPS's criminal history information. Allow for counties to be reimbursed for representation provided by a public defender's office when it is appointed to represent an indigent inmate in a situation where the State Council of Offenders cannot do so. Repeal the requirement that public defender attorneys must inform the appointing judge of the results of any investigation into a defendant's financial circumstances. Allow attorneys with a private criminal practice to work part-time for public defender offices. Require a court to appoint an attorney to represent an eligible eligible indigent defendant to investigate a claim and file a writ of habeas corpus in limited instances when the state represents that the defendant may have a potentially meritorious claim of relief from a prior conviction. That is when the state makes that recommendation. Ensure that magistration records are properly preserved. Ensure payment of expenses for attorneys to meet with defendants held in out-of-county jails, and add two members to the TIDC's board, a director of managed assigned counsel program and a justice of the peace, municipal court judge, or an appointed magistrate. What you can expect from the committee's substitute is, in summary, there'll be some minor cleanup language, of course. There'll be a major change with regard to Section 7, which deals with the MAC Oversight Board. In talking with TIDC, it's been agreed upon that this particular session needs a lot of work, and we're not going to get that done this session, so we're going to take Section 7 out. There's also, under Section 3, some significant work that we're going to do. We've been having conversations, had some today, with regard to the appointment of counsel under Section 15.17 of the Code of Criminal Procedure. Thank you for your consideration of this bill, and I'm looking forward to any questions you might have. We do have significant, and I don't mean a lot, but we have guys here to testify on this bill that have been working day to day on putting it together. And I guess I'm just going to go ahead and reserve to close. Right to close.
Not that you're right, but we're going to reserve it.
Right.
All right, thank you. Representative Smith, any questions at this time? All right, thank you, sir. All right, the chair calls Aaron Abrams. Ms. Abrams, thank you for being here today. We show that you are registered as Aaron Abrams and you're here testifying on behalf of the Texas Fair Defense Project and that you'll be testifying for the bill. Is that correct?
That's correct.
You may proceed.
Yeah, my name is Erin Abrams, and I'm here on behalf of the Texas Fair Defense Project. TFDP is a nonprofit organization that fights the criminalization of poverty in Texas, which includes ensuring a right to representation regardless of economic status. In turn, we support HB 1528 as it includes several key provisions that would enhance indigent representation throughout the state. Many of the changes in this bill address specific gaps in the indigent defense system as identified by public defenders and managed assigned counsel offices throughout the state. These provisions went through a lengthy vetting process that included a variety of relevant stakeholders, including the board of TIDC. We support this bill, and I would just like to highlight two particular provisions that are included. The first change that I'd like to highlight is in Section 2 of the bill, which addresses Article 1517, subsection F, requiring records of communication between the individual who was arrested and magistrates to be retained for at least 3 years will significantly help with oversight of indigent defense. These records show that the individual was informed of their right to counsel and whether or not they requested counsel after being informed. And if these records were more accessible, it would help in understanding why so many people accused of misdemeanors are not receiving counsel. This will also help ensure that this information is available even if formal charges are not filed for an extended period of time. The second change I'd like to highlight is in Section 8 of the bill, which addresses Article 26.05, subsection D. This would ensure that court-appointed lawyers are reimbursed for the cost of traveling to visit a client who is in a correctional facility over 50 miles from their trial court. It also covers any costs related to confidentially interviewing a client remotely. This is particularly important for lawyers representing clients who are accused of low-level offenses, as the flat fee for these cases is very low. With many clients being held in rural areas, court-appointed lawyers may wind up losing money for visiting their client just once or twice, depending on where they're housed. Reimbursing these expenses would help ensure that costs of travel don't impede on an individual's right to receive adequate representation. These are only two examples of the countless changes that public defenders and managed assigned counsel offices have identified to include supporting HB 1528 means supporting the right to representation throughout the state. Thank you so much.
Thank you, Ms. Abrams. Any questions for Ms. Abrams at this time? All right, thank you for your testimony.
Thank you.
The chair now calls Paige Williams. Ms. Williams, we show you registered as Paige Williams on behalf of the Dallas County District Attorney John Caruso, and that you'll be testifying for the bill. Is that correct?
That is correct.
All right, you may proceed.
My name is Paige Williams. I am here representing Dallas County Criminal District Attorney John Caruso in support of this bill. Those of y'all who have been working with me since the beginning, I am not the one that normally testifies. So I'd like to take this opportunity and thank Representative Smith for putting the best part of the bill in Section 1, and there's no controversy over it, which is what I'll be addressing today, Section 1. Currently, under post-conviction writs of habeas corpus law, the state can only ask for a defendant to be appointed counsel in a situation where we have to represent that the defendant's not guilty. Well, if we convicted him, why can we then come back and say he's not guilty? Like, so it, for starters, doesn't make a whole lot of sense the way that it is written. Or he's convicted of only a lesser included offense, or he was convicted under a law that has now been deemed unconstitutional. This is rare in post-conviction writs, but what we are asking in this bill is to change it to language that we actually use. 1, is or may be actually innocent. 2, is or may be guilty of only the lesser included offense. Was or may have been convicted or sentenced under a law that was unconstitutional, or was or may have been convicted or sentenced in violation of the state or the United States Constitution. These are instances in where we have individuals who are potentially sitting in prisons wrongfully. The stopgaps that have been put in place through 2 interim workshops with TIDC are that 1, the state has to request it, and 2, the judge has to decide that there is enough there to appoint. So we believe that we have sufficiently narrowed this to the point where we can at least hopefully ensure that we do not have individuals sitting in prison that don't belong there, and that we can get them defense attorneys when the state sees situations in which we can't get to the information and we need a defense attorney to be able to do so. Thank you.
Any questions? Perfect. Any questions for Ms. Williams? All right, thank you for your testimony.
Thank you.
Next chair calls Jim Allison. Mr. Allison, if you would please state your name, who you're here on behalf of, and your position on the bill.
Thank you, Mr. Chairman, members of the committee. My name is Jim Allison. I'm the senior counsel of the County Judges and Commissioners Association of Texas. We're appearing today on the bill, but we appreciate the opportunity to work with Chairman Smith, and I fully expect that our concern will be resolved, and we'll be in support of the substitute, and we will so advise you at the appropriate time. The County Judges and Commissioners Association has been a partner with the state in indigent defense now for over 20 years, and working with the TIDC and now Chairman Smith, we've made great progress. But our role is to help see that there's a fair, effective, and efficient criminal defense system, and that we're maximizing the use of taxpayer dollars. And we appreciate Chairman Smith shares that concern, and our concerns in Section 3, I think, will be fully resolved in the substitute. I must say, though, what you already know, that in 20 years, we've gone from no system that was fully funded at $90 million or so by county taxpayers to, I think, one of the better systems in the country, but now costs us over $300 million a year. With the state only providing 17% of that funding, about $50 million, that leaves the remainder still coming from our local property taxpayers. We are working, of course, with the Appropriations Committee this time to see if we can't catch up and improve that state participation, because even with that use of taxpayer dollars, we're still 46th in the country, 46th in the country in per capita funding for indigent defense.
So the TIDC, we believe, does a great job with very limited amounts to work with. We appreciate what y'all do to support them, and counties will continue to do our part, but we certainly need to look at ways to relieve the property taxpayer of some of that burden. And I think this bill, once we get that perfecting language in Section 3, will go a long way toward that, and be happy to answer any questions.
Any questions for Mr. Allison? Chair Darby?
In part of the bill analysis that we're provided, part of the statements were made, it repeals the requirement that public defender attorneys must inform the appointing judge of the results of any investigation into the defendant's financial circumstances.
Yes, sir.
Could you explain that to me, why?
Yes, sir. Again, I serve as a member of the work group for TIDC, and that issue has come up over the years that creates a very potential conflict between the attorney and the client. As you know, attorney-client information is confidential by law, and that's one of the most sacred privileges that we have in court, that the client be able to tell the attorney truthfully everything about them, including their financial condition. And we take very seriously the responsibility to make sure that everyone who gets an appointed counsel is actually indigent and eligible for it. But we don't believe it's appropriate to ask the attorney for that client to be the snitch that turns them in.
I didn't realize the distinction here is
Yes,
the public defender that must inform.
Counties and the court have full power to investigate the defendant and their representations concerning their financial ability. But we felt like that we probably were going a bit far if we tried to put that load on counsel for the defendant.
Thank you.
Any other questions for Mr. Allison? Thank you for your testimony.
Thank you.
Chair now calls Bradley Hargis. Mr. Hargis, if you would please state your name, who you're here on behalf of, and your position on the bill.
Yes, sir. Thank you, Chair. My name is Bradley Hargis. I am the Executive Director of the Capital Area Private Defender Service, which is a managed assigned counsel program here in Travis County, Texas. I'm here to testify in favor of the bill and to provide any clarification or information I can to the committee regarding managed assigned counsel. As I've previously testified, managed assigned counsel is a maturing model of delivering indigent defense in Texas. In recognition of that maturing model, which we believe is a very successful partner working with public defenders to make sure that all indigent clients receive the best possible defense that we can given the resources we have. We've worked with TIDC, many of the directors through the legislative process, and thank you so much, the representative, for bringing this bill. There's many things that are excellent in this bill. I'm going to focus only on a few managed assigned counsels pieces. As part of the maturing process, we've recognized that current existing law may leave some gaps or uncertainties. So the recommended language or this bill ensures that MACs can effectively oversee attorneys participating in their programs by clarifying the standard by which they can remove attorneys for individual cases. There is case law that provides guidance to the courts. Obviously, public defenders have a clear employment relationship, but there was unclear guidance for what standards managed assigned counsel programs can use. This bill clarifies that. It ensures the confidentiality of essential services. So part of the managed assigned counsel's program's responsibility is to ensure the use of experts, investigators, social workers, and other supportive resources. It is unclear today that those requests may be entirely covered by the attorney-client privilege. This bill makes that clear, that these necessary services that attorneys request, that they can provide the information necessary to have those evaluated, and more importantly, the records of those requests would be protected. It also allows the delegation of authority of MAC directors to meet volume demands in their jurisdictions. There is at least one place regarding, it says the director shall. As MACs have expanded to now the most populous counties in the state, it is unrealistic for the director, him or herself, to make each of those decisions, and it's necessary to delegate. And as highlighted, it creates a parity with public defenders accessing DPS records. So we believe that there's a lot of excellent things in this bill, but as the managed assigned counsel piece of it, there's a lot of valuable changes that are necessary to ensure that managed assigned counsel continues to protect the privacy, the efficacy, and the quality of representation, and we hope that you will pass this bill out. Thank you. Any questions?
Members, any questions for Mr. Hargis? All right, thank you for your testimony. Chair now calls Scott Ehlers. If you would please state your name, who you're here on behalf of, and your position on the bill.
Yes, sir. Good afternoon, Mr. Chair, members. My name is Scott Ehlers. I'm the Director of Public Defense Improvement for the Texas Indigent Defense Commission. I'm testifying on HB 1528 as a resource witness. As Representative Smith had mentioned, HB 1528 contains 10 legislative recommendations from the Texas Indigent Defense Commission's governing board. I did want to let y'all know that it's particularly timely for y'all to be considering this bill this week because this Saturday is the 60th anniversary of Gideon versus Wainwright, the unanimous Supreme Court decision which recognized the Sixth Amendment right to counsel, right to appointed counsel, for indigent defendants in state court. And I wanted to let you know that this Friday in the Capitol Auditorium at 9 a.m., TIDC, along with the Texas Tribune, we're having a symposium on our successes and the continuing public defense challenges that we face here in Texas. So I hope that you or your staff members can attend or watch on the Texas Tribune website. Regarding HB 1528, I'm happy to answer any particular questions that you have about any of the provisions. I did want to reemphasize the process that we come up with, that we use to develop these proposals. We are statutorily directed by you to come up with legislative proposals to improve indigent defense in the state, and we held two work group meetings last summer where we brought together judges, county and court administrators, defense lawyers, prosecutors, legislative and governor staff. They were all invited to participate. Legislative work group makes these recommendations to our Policies and Standards Committee, which then go to our full board, and that's how these recommendations get to you. So I'm happy to answer any questions you might have on the particulars, but that's how we got here today.
Members, any questions? All right, thank you for your testimony.
All right, thank you.
Is there anyone else here who would like to testify on, for, or against House Bill 1528? Hearing none, Chair recognizes Representative Smith to close on the bill.
Thank you, Mr. Chairman. Thank you all for your time, and I'll close.
All right, if there's no objection, House Bill 1528 will be left pending. Members, any objections? Hearing none, House Bill 1528 will be left pending. Thank you, Mr. Smith. Chair recognizes Representative Slauson on House Bill 28. All right, Chair recognizes Representative Slauson to on House Bill 28 and lays out House Bill 28.
Thank you, Mr. Chairman and members. I appreciate the opportunity to lay out House Bill 28, the Todd Hoagland Act, for you this afternoon. This is a refile of a bill from the 87th that passed unanimously out of that committee, but didn't make it to the floor in time. So I particularly appreciate the chair's expeditious moving of this bill to hearing today.
Well, just for the record, let's give credit where credit is due with Chairman
Moody.
That's
Yes,
right, doing a good job. Thank you.
The purpose of this bill is to allow a penalty enhancement from a second-degree felony to a first-degree felony for certain aggravated assault crimes, where the assault with a deadly weapon causes a traumatic brain or spinal injury that results in a persistent vegetative state or irreversible paralysis. Currently, the law allows this enhancement in situations resulting in a serious bodily injury where the victim and perpetrator are involved in a dating, family, or household relationship. HB 28 would allow the same enhancement where the result is an extreme injury to the victim without regard to any type of relationship between the assailant and the victim. That's the purpose of the bill, but the why behind the bill is compelling. And I think it's actually best laid out by the testimony of the individuals who are directly impacted by this law, who are here today again from Erath County. And I thank you in advance for hearing them. We all greatly appreciate your time, and I am happy to answer any questions that you have. And in keeping with the tradition of the day, I would request to have the opportunity to close.
You will have that opportunity, Representative Slauson.
Thank you so much.
Thank you. All right, the chair calls Denise DeForest. If you would please state your name, who you're on behalf of, and your position on the bill if you're testifying for, on, or against the bill.
My name is Denise DeForest. I'm for this bill. I'm testifying on the behalf of my daughter, Brandy Todd, who you will hear from. I am a mother.
You're testifying on your own behalf.
On my own behalf, okay. I'm not a lawyer.
You're doing great. You're doing great.
I'm a mother, and her father and I, our marriage is 41 years, raised 3 children. We taught them right from wrong. When our boys got caught with a potato gun and with 24 dozen eggs, they got in trouble. We always taught them that they had to pay for what they do wrong, that nothing is given to them, nothing is entitled to them, but they were going to have to follow the rule of law. Well, all of that changed when my daughter was stabbed, actually, on this day. She was stabbed in the back. She was sitting on a park bench watching her 2 children. She did not know this person. She'd never met him. He stabbed her and paralyzed her. She's been sentenced to a life sentence. At the time, her daughter was 9, her son was 5. They will never escape this sentence. We have to plan, her children have to plan on which one of them are going to have to help her when we're gone. Whether we knew this person or not, in fact, if we knew this person, we could have had some idea this might happen. But we didn't even know him. We didn't know he lived in our town. We didn't know he was at the park and that he could do this. I'm asking you today, as mothers, as fathers, as uncles, as brothers or sisters, to think that you could be walking into Walmart and someone who is mentally ill can just decide to do this to one of your family members who did not live any lifestyle that you would even think this could happen to. When we got the call, I thought, who could do this? I was trying to think, who do we know that acts this way? And I could not come up with anybody that we knew that could do this. And when we found out that this person has had a lifelong history of mental illness and was shipped from county to county to county, we was quite shocked. And I just want you to really think that this could be you. This could be a family member of yours. Thank you.
Ms. DeForest, thank you for your testimony. Members, any questions? Thank you. Chair next calls Jet Smith. If you would please state your name, who you're here on behalf of, and your position on the bill, on, for, or against.
Mr. Chairman, members of the committee, thank you for having me. My name is Jet Smith. I'm here on behalf of the Erath County District Attorney's Office. I'm here to testify in support of House Bill 28. I'm a felony prosecutor and have been so for over a decade. I do work with the Erath County District Attorney's Office. And in that, I want to take you back to the early morning of December 2017. I was called out to a local apartment complex there in Erath County in the early hours of the morning. I remember it was particularly cold that day, 20 or 25 degrees. When I arrived on scene, I met with the police officers who I had worked with for years and learned that a young woman named Jamie Hoagland, 19 years old, had been shot in the doorway of her apartment, and at that time, the assailant was unknown. We went for 2 or 3 days wondering if a random gunman was on the loose, but due to good police work and diligence on the part of the Stephenville Police Department, were able to learn that a man by the name of Sean Layton, a methamphetamine addict, had gone to the apartment complex that night with the intent of assaulting his drug dealer, Jeremy Loud. But whether he was high on meth or just made a mistake, he got the wrong door. Jamie Hoagland answered the door, and as soon as she did, he shot her in the face with a 9mm pistol. That was the last moment she could feel her legs. She was paralyzed until the end of her tragically short life. When I received the case on my desk a few weeks later, I had to evaluate it, and I knew we had an aggravated assault charge. And by that time, I knew that Jamie was most likely totally paralyzed. And I racked my brain thinking, how is there no way that I can try to get this man more than 20 years in prison for what he did, for randomly shooting a person and paralyzing him? I searched the penal code. I had conversations with my boss, Mr. Alan Nash, the elected DA there in Erath County. The law at that time, and as it stands now, does not provide a way to sentence somebody for this type of offense to more than 20 years in prison. That was a tough conversation with Jamie and her family. Jessica, her mother, is here today. I expect her to testify how this has impacted her life. But what House Bill 28 does is it corrects this injustice for future victims. It is a mere addition that provides for a specific carve-out under Penal Code 22.02 subsection B, the aggravated assault statute, and it provides that if a person uses a deadly weapon and causes a traumatic brain or spine injury to another that results in a persistent vegetative state or irreversible paralysis, that offense is then treated as a first-degree felony, carrying a range of punishment from 5 to 99 years or life in prison. The jury found Sean Layton guilty in 15 minutes, and there was a huge community outpouring wondering why we could only sentence this man to 20 years in prison. I thank you for your time, and I welcome your questions.
All right, members, any questions for Mr. Smith? Thank you for your testimony and your work on this important
Thank you,
case.
Mr. Chair.
All right, this time the chair recognizes Brandy Todd. Just to the side. Let me get rid of it. We're going to pull that down for you. Give me one second. Will that work for you? If you would.
I'll be loud.
All right, thank you. If you would, please state your name, who you're here on behalf of.
My name is Brandy Todd, and I be here on behalf of myself.
And I bet
and
you're
I am-
testifying for, right?
Yes, I am. I just want to tell you guys, kind of lucky today because it's my stab anniversary, 13 years. 13 years ago today, probably at this time, I was probably being care flighted by this time in the afternoon. But anyways, I'll go ahead and get going. So when I was told I had to have something to say today, I was my mind went blank, which is weird because I don't ever have not enough to say. Do I tell you about my family? They're my most prized possessions. They're my favorite gift from the universe. My dad is a war hero, and my mama is the strongest woman I've ever known. What about my beautiful daughter, Olivia, who's a hurricane in skin? Or my sweet, gentle son, Lincoln, who at 4 years old watched a stranger stab his mother? My brother Cliff's strong, silent strength has been a blessing. And you love my sister Dree, who's my biggest defender and partner in crime. I can't forget my brother Jeremy, who we lost 2 years ago. And his daughter's here with us today, so that's kind of nice. Do I tell you about all the things I love most, like floating the river and camping? I love my amazing job and coworkers who put up with me and keep me sane. I could tell you about my horse. I love to ride, and her legs take me where mine cannot. I love to travel, and I love beaches and bonfires and barbecues. I could tell you about my life BS, that's before stabbing. I was an amazing athlete, and I ran a mile every night before my shift at work. I was on the company basketball team and I had a job that I enjoyed and I loved to dance. But I've decided to tell you some really uncomfortable truth about my life after a stranger stabbed me. And keep in mind, my case is best case scenario. It doesn't get much better than what happened to me. My son doesn't remember a time when I could walk. When this happened, he became developmentally delayed. My daughter battles anxiety and they both have PTSD. I could tell you about the time I fell in a handicapped stall that was too small. I didn't have my phone to call my mama, and I was too embarrassed to call out to strangers for help. I sat in that stall with my legs tangled between the toilet paper dispenser and my wheelchair. And by the time I was able to pull myself up, I was sweating and bleeding and silently sobbing. Do you want to hear about the times that my daughter and son have had to help get me off the floor? Or maybe you'd like to hear about how I have to plan my day around where I can go to the bathroom. Do you know what a bowel program is? If not, I'm sorry, I'll hurry.
You're fine.
I'll spare you the details because dignity is hard to hold on to. I could talk to you about UTIs and osteoporosis at 41 years old, or the constant nagging fear of a pressure sore. The monetary cost of becoming paralyzed is unbelievable. Medications, wheelchairs, and modifications to vehicles and homes are just the tip of the iceberg. Medical bills will ruin your credit, and I'll pay for catheters for the rest of my life. I fell in the shower once, and as I sat there on the cold floor, naked and sobbing, waiting for my parents, I begged God or Allah or the universe or whatever to do something, to do anything. I'm sitting here today, thankfully fully clothed, asking you to do something. I'm asking you to stand for those who can't stand for themselves. The man who stabbed me will be free in 7 years, and I serve the life sentence. Thank you.
Thank you, Ms. Todd. Thank you. Thank you for your testimony. Chair, next call is Jessica Hogland. Ms. Hogland, if you would please state your name and who you're here on behalf of, and if you're testifying for the bill.
My name is Jessica Hoagland. I'm here testifying for myself, and I fully support this bill.
Great. Thank you.
Thank you. My daughter Jamie was a victim of a violent crime in December 2017, the one that Jet just spoke about. She was just in her apartment when someone knocked on her door. She looked out her peephole and didn't see anyone, and after another knock, she opened the door. She had thought a kid was just playing ding-dong ditch. But as she was opening the door, she was shot at point blank by a total stranger. As a result of the shooting, Jamie's spine was shattered and her spinal cord was severed. Her life was immediately changed. And she knew the life of a quadriplegic. Her freedom, independence, and life was forever changed, along with mine. Overnight, I had to learn to be a full-time nurse to care for her 24/7. Just a glimpse of how her life was impacted: normal walking, providing for herself. She couldn't use the bathroom on her own. She needed total help with her dressing, total help with meals. In her own words, she felt like an infant and totally helpless. The physical and emotional toll that the shooting caused is unimaginable. It's more than just being in a wheelchair. Life was never the same from this point of the shooting. Jamie's life consisted of hospital stays, surgeries, therapy visits, specialty appointments. If Jamie was here, I know she would be pleading for a change. But unfortunately, Jamie can't be here today because she's gone on to heaven. I'm asking you to do something to give peace of mind and a sense of justice to future victims and their families. The offender that hurt my daughter received a 20-year sentence, and he could probably be out in just 10 years. Once he's released, he will then go back and proceed with his life like normal, whereas his actions caused lifelong damage. and pain. So please consider supporting this House bill. Thank you for your time.
Thank you for your testimony. All right, is there anyone else here that would like to testify on, for, or against House Bill 28? Hearing none, Chair recognizes Representative Slauson to close on the bill.
Thank y'all so much. I didn't realize when Chairman Moody set this hearing for today that this was going to be the 13th anniversary of the last day that Brandy Todd walked or ran or danced. But it is very clear that woman has not quit standing. And it strikes me when she says to all of us that dignity is hard to hold on to, because I hope you take with you that justice does not have to be. And I ask that you will favorably report this bill out of committee expeditiously and support it when we get to the floor. Thank you all. If you have any questions, I'm happy to entertain.
Sorry.
Just real quick,
I didn't hear.
Mr. Chair.
Yep. Chair recognizes Chairman Moody.
And I apologize, I had to step out and miss the beginning of this, but certainly not lost on us how important this is and the fact that it's an anniversary. Our committee is doing things a little bit different than usual. We're looking at bills that don't have much opposition early, and we're trying to move them as fast as we can. And later today, I intend to take this bill up for a vote. So just to let you know, let the families know while they're still here.
Thank you so much, Mr. Chairman. Appreciate it.
Members, if there's no objection, House Bill 28 will be left pending. Any objection? Hearing none, House Bill 28 is left pending, and Chair turns mic back to Chairman Moody.
Chair lays out House Bill 1088 and recognizes Representative Ann Johnson to explain that.
Thank you, Chairman Moody, Vice Chairman Cook, and members of this committee. House Bill 1088 is a refile from last session. It passed this committee unanimously. It passed local and consent in the House and died in the last day in the Senate. What this bill, again, seeks to accomplish is the protection of our community supervision probation officers in the case where they are sued in a writ of habeas corpus. So typically when we think of a writ of habeas corpus of release the body, that suit is usually filed where somebody is in custody, and that suit may go to the judge or may go to the sheriff to release the body. In rare circumstances, when somebody is on probation, on papers at home, and they file that suit, then it is the head of the community supervision department that is filed with that suit. Typically, you would expect the county attorney or the district attorney to respond to that suit, but we have seen a couple of circumstances where by either conflict or straight up refusal, they have refused to represent the probation department in that hearing. And so what this bill says is that they must either do it, and if for some reason they decline or have a conflict, that the Attorney General of the state of Texas will pick up that obligation. We do have a couple of witnesses here who have incurred those suits and had to go out and find private counsel who are not accustomed to these cases, are having to be paid out of pocket. And again, these are some of our most vital public servants. I appreciate your consideration on this bill with a couple of witnesses and ask for the right to reserve the right to close on the bill.
Yes.
Thank you, Chairman.
Absolutely, thank you. Members, do we have questions? No? Okay, we'll move to witnesses. Chair calls Dr. Teresa May.
Good morning, or good afternoon, Chairman, members. Dr. Teresa May, I'm the Director of the Harris County Community Supervision and Corrections Department. I'm here on behalf of myself and the Texas Probation Association. And as Representative Johnson stated, a number of us have had these writs of habeas corpus filed.
And you're in support or opposition?
I am in support of this bill, and our A number of our departments have had these bills, or these writs of habeas corpus filed. Most of them are in federal courts. They're very cumbersome and very expensive. In Harris County, obviously we're large. I've had more than one. I've had probably about 5 since I've been there. And in a couple instances, my district attorney was able to help me, but in others, that hasn't always been the case. So it is really critical that, like all of our other cases where we get sued, the Attorney General represents us because primarily we are state funded. And when we get sued, we have to spend state dollars for representation. And we really appreciate your support of this bill and anything that you can do.
Thank you, Doctor. Members, do we have questions? No? Thank you.
Thank you.
Chair calls Allison Martinez.
Good afternoon, Chairman Moody and honorable members of the committee. My name is Allison Martinez, and I am the director of the Webb and Zapata County Community Supervision and Corrections Department. I am also here on behalf of the Texas Probation Association in favor of House Bill 1088. As a newly appointed director for CSCD, I have not faced any writs of habeas corpus personally, or my department hasn't during my tenure, but as a former government attorney, I have seen firsthand moments or the capacity and the limitations that district and county attorney offices may have when asked to represent CSCDs on matters such as habeas corpuses for CSCDs. Instances where the local district attorney or county attorneys may not be able to handle the cases, CSCDs are then burdened with the task of hiring outside private legal counsel, using state funds to cover costly legal fees. Outside counsel is not privy to the many court documents, records, and filings needed to handle these cases. The Office of Attorney General is equipped to handle these cases. As a governmental entity, the Office of Attorney General has better access to these records and has the capacity to handle these matters in federal court. The Office of Attorney General already handles writs of habeas corpus for in-custody cases. All we are asking for today is that it be extended for cases where community supervision comes to play. To extend that to include our cases and to help our departments in these manners. Thank you so much for your consideration, for the opportunity to speak on this House bill today.
Thank you. Members do have questions? No?
Thank you.
Thank you. Have a great day. Chair calls Sheila Gladstone.
I'm Sheila Gladstone, and I'm in favor of this bill. I'm an attorney who represents CSCDs throughout the state. I'm a private attorney at a law firm. I've been specializing in representing CSCDs for 35 years. In the last 15 years, we've been called upon to have to handle quite a few of these. We are not equipped to do it. We are not very qualified to do it. And so the first one was just a nightmare because we had access to nothing. The AG's office refused to do it under the current statute. The DAs refused to do it. I've represented, we've handled these now for about 4 or 5 CSCDs. So I'm here to answer. I can pass right now and be here to answer any legal or technical questions as they come up after the next witness.
And I'm showing that you're here in support of the bill. Is that correct?
Correct.
Okay. All right, members, did we have questions? No? Thank you very much. I appreciate your time.
And I can answer any question.
And we have your contact information that way. If we have follow-ups, we will do that. Thank you so much for taking the time to be here today. Chair calls Jed Davenport. If you could, just for record purposes, state your name, whom you represent if someone other than yourself, and then your position for, on, or against the bill.
My name is Jed Davenport. I am the director of the Concho Valley CSCD, which is Tom Green County and 6 surrounding counties. I'm testifying for House Bill 1088. This will be a good fix for probation departments. I just want to take a few minutes to let you know what we encounter. Here's a good example of what your bill will help fix. We were served notice by the federal courts on an unrepresented defendant who pretty much in his writs named everything but the color of the courthouse as issues. He was also incarcerated, or he was in the penitentiary for another offense that occurred in Victoria. And our prosecutors opted to wait until he had served out that sentence. I think he would have had some time remaining on his probation term to handle our MTR. So that's structural custody. We were basically named in this suit for no other reason than we had an open order of probation. All of the things that this defendant was stating in the writ had absolutely nothing to do with CSCD control. The AG's office was able to get the warden and the penitentiary dismissed from the suit rather quickly. Ours drug on for well over a year, and again, just filing responses to the federal court cost us in the ballpark of $15,000. So again, this bill would, our attorneys were, our county attorneys in the outlying county did not feel comfortable, had no really expertise in this area. Our DAs, of course, had huge dockets. And of course, in the middle of that, I think they had some, they were named as some issues in the writ as well. So having this option in this bill for DAs or prosecutors, or I, as a director, I can't express to you how much I very much wouldn't like to be in a federal prison because I didn't respond or somebody didn't respond for us. So that's what this will fix. It will allow us to more efficiently and effectively respond to these kinds of writs. Thank you for your time. If you have any questions,
Jed, thank you so much for your time. And do we have any? I just want to make sure. Okay, we're good. Thank you very much. Okay, is there anyone else wishing to testify on for or against House Bill 1088 at this time? Chair sees none, recognizes Representative Ann Johnson.
Thank you very much for your favorable consideration of this bill. All it does is fix a loophole to ensure that this community and public service entities are picked up by the AG when others are unequipped or fail to do it. Thank you.
All right, thank you. Members, if there's no objection, HB 1088 will be left pending. Is there any objection? The chair is none. HB 1088 is left pending at this time. We've moved to that part of the schedule where the only bills left are ours. So these are all easy ones. Chairman Leach, let's start with yours. Chair lays out HB 1736 and recognizes Mr. Leach to explain the measure.
Thank you, Mr. Chairman and Vice Chairman. This bill passed the House 135-6 last session. It's a bill relating to the imposition of the death penalty in Texas. I believe strongly that as a death penalty supporter in the most heinous cases that it's okay and actually good and proper for us to question the system, for us to ask tough questions and not blindly support the imposition of the death penalty. I believe it's the most important duty we have as lawmakers when it comes to continuing to support the imposition of the ultimate punishment. That's the taking of someone else's life for a crime that they either did or did not commit. I'm concerned about the current state of the death penalty in Texas, the way it's being executed, no pun intended. The death penalty should be reserved for the worst of the worst offenders, for their most heinous crimes. But the current law of parties, which is what this bill deals with, undermines, I believe, the integrity of our entire system of capital punishment. Members, this bill was, like I said, voted on with 135 votes in the House last session. It didn't, I don't believe it even got referred in the Senate to committee. It might have at the last minute, but time ran out. But this is an important bill that I think strengthens our system of capital punishment in Texas, relating to the law of parties. The case that really got me thinking about this a few years ago was the Jeff Wood case. In August of 2016, Jeff Wood was scheduled to be executed. Many of us, Republicans and Democrats in the House and Senate, banded together and pushed for effectively pushed for a stay of his execution. Jeff Wood was the getaway driver in a planned robbery back in the mid-90s of a convenience store. Mr. Wood sat in his truck outside of the convenience store when his friend went in and was intending on robbing the convenience store, of taking the safe in the back room, and they just wanted money. Jeff Wood was the getaway driver for a robbery. He committed a crime, but what he did not know, evidence showed, is that his friend was armed. When he went in the store, the store clerk actually ended up fighting back, and his friend shot and killed the store clerk. Both Mr. Wood and his friend, who's since been executed by the state, were convicted of capital murder and sentenced to death. Mr. Wood has been sitting on death row for nearly 30 years. And he was sentenced under the law of parties. So this case captured my attention. I don't want to belabor the point, but this bill is intended to address the situation and to prevent the situation where a burden, the requisite mens rea burden, is not satisfied. This bill brings Texas in alignment with Eighth Amendment standards, states that to be convicted of capital murder under a conspirator party rule, a defendant was a major participant in the underlying conspiracy and acted with reckless indifference to human life. If the prosecution does not satisfy this burden, then the defendant may be convicted of murder and sentenced to up to 99 years in prison. This does not create a loophole in our justice system. Second, this bill states that in order to impose a death sentence, the jury must find that the defendant intentionally killed the victim or did not actually perpetrate the murder but intended to kill the victim or another. So in that instance, in Mr. Wood's instance, I think of the case of the Texas 7 from several years ago, where the Texas 7 knew and agreed on, there was a meeting of the minds that they had specific roles in what was going to be a murder that was carried out, and but for any one of their actions, that crime would not have been committed. In that case, the death penalty would still be able to be imposed. Finally, the bill as filed, the bill in front of you contains a really important amendment from Chairwoman Thompson, from Dean Thompson, during the last legislative session. That amendment, which is currently in the bill, requires a review of the criminal conviction of each inmate serving a death sentence right now who's been found guilty under the law of parties, to identify those individuals, men and women, for whom clemency could possibly be recommended to the governor. Again, I think it's right and proper and appropriate for us, whether we support the death penalty or not, for us to ask the tough questions and be willing to make revisions and improvements that strengthen our system of capital and punishment where we can. And that's what I believe this bill does. And so, Mr. Chairman, with that, I'm happy to answer any questions and request the right to close.
I'll appreciate it. Members, do you have any other questions for Mr. Leach, or reserve them for later? If not, we'll take public testimony. Chair calls Nikki Presley.
Thank you, Chairman Moody and members. My name is Nikki Presley. I represent the Texas Public Policy Foundation and Right on Crime, and we are in support of HB 1736. The chairman did a great job laying out this bill, so I'll try to keep it short. The law of parties is unique in that it's premised not on the actual acts of the defendant or what the defendant intended to do, but rather on their relationship with the actual perpetrator. It allows defendants to face capital punishment on the basis that they should have anticipated that their co-conspirator would commit a more heinous crime. This wouldn't eliminate the state's ability to prosecute defendants via the law of parties. It would just ensure that capital punishment is reserved for the most serious crimes committed by those who intentionally and knowingly cause the death of an individual. So thank you for considering this legislation, and I'm happy to answer any questions.
Nikki, thank you. Members, do you have questions? Thank you, Nikki. Thank you. Chair calls Jessica Dickerson.
Good afternoon. My name is Jessica Dickerson, and I'm with Texas Prison Community Advocates, and we support this bill. In the United States, 11 people have been executed who not killed anyone. In In every other state, this only happened once, but in Texas, it's happened 6 times. A #1 trophy I don't think we should be proud of. I'm not a defense attorney, I'm an advocate, and maybe they can find better research than I can, but that's about the only data point I've been able to find in my research so far. So the true reach of law of parties is not really known. As an advocate, I'm privileged to hear the stories of those incarcerated under law of parties, and they all come with common threads. In one of these recent stories, a 15-year-old joined some friends, unaware that there was a plan in place, and that under death threat, he found himself way over his head. He was further coerced to make statements without counsel or a parent present to the detectives that he knew from church and he felt safe with. At trial, his attorney and he thought they were defending murder, to find out they were defending law of parties. Another common thread is that defendants often believe that they are fighting a much more significant charge with a much higher burden of proof than law of parties requires. This trial situation often comes with stiffer sentencing, and those that are guilty plea bargain. Those that believe in their innocence go to trial and oftentimes receive disproportionate sentences. In the case of this young man, but for his age, he might have received the death penalty. Instead, he received 60 years, while the person who committed the actual murder received 20. While the death penalty is what this bill is about and is the most egregious issue, many are convicted of the other death penalty under law of parties, which is life without parole. Representative Canales mentioned the scarlet letter of incarceration. Imagine being labeled a murderer when you hadn't killed, and then imagine facing execution when you've never killed. We do support this, and we hope that you continue to move it through committee. And thank you very much for your services today and to the state. Appreciate you.
Thank you. Thank you very much. Chair calls David Emmerich.
Dave, come talk about this one too.
Chair calls Allen, please.
Mr. Chairman and members, my name is Alan Place. I'm here representing Texas Criminal Defense Lawyers Association, and we're in support of the bill. As we read it, I'll be very brief. Sections 1 and 2 is laid out by Chairman Lee to recognize the current U.S. jurisprudence concerning what Texas calls law of parties or conspiracies. Other states use the word accomplice. We believe the last line, I believe in Section 2, that makes it inapplicable to the death penalty is a proper reading of Tyson versus Arizona, which is basically the law regarding this particular subject matter from the U.S. Supreme Court. Section 3, as one of the earlier witnesses indicates, it allows certain circumstances as spoken about in Tyson that would allow somebody that is not the actual person that took the life of another person. It has the parameters that can be used, and I believe that Section 3, as laid out in Chairman Leach's bill, addresses that in a proper manner. The last section, which I believe you said Ms. T may have added that as an amendment on the floor, I'm not sure. But we do think that's appropriate. I'm certainly not here to speak for the parole board, but certainly I think that it is their ongoing duty to review circumstances of that nature as they appear and as indicated so by this body. So I'd be glad to take any questions.
Thank you, Alan. I appreciate it. Members, do you have questions?
Thank you, Mr. Chairman.
No? All right. Chair calls Terry Bean.
I realize that I'm on a time limit. It was a little bit more than that. I apologize, but I've given you all a copy. And if you have any other questions, please feel free to contact me. Thank you all for allowing me to voice my concerns today. My name is Terry Bean, and I'm here to testify in support of this bill. I am a person with many roles. I'm a wife, a mother, a Texas teacher, but I'm also a family member of a Texas death row inmate, who Representative Leach spoke about a minute ago. And I've come here to publicly give testimony and to educate and raise awareness about this poorly written law entitled the Law of Parties. In Texas, you can be found guilty of a crime in 3 different ways. You can be the perpetrator who actually commits the act. You can be found guilty under the Law of Parties if you solicit, encourage, direct, aid, or attempt to aid another person who commits the act, which is Statute 702A, meaning that you purposely had some kind of role in the situation. Or third, you can be found guilty is under the Law of Parties 702B, which states that if in the attempt to carry out one conspiracy, such as robbery, then another felony is committed, such as murder, then everybody, all conspirators are found guilty of the felony actually committed, though having no intent to commit it if the offense was in furtherance of the unlawful purpose that should have been anticipated. And that's the thing that we're fighting, is it should have been anticipated, meaning you have to be a mind reader. My brother Jeffrey Wood was convicted under 702B of this law in 1997 for a crime that he, one, was physically not present for and had no knowledge would even take place because he was ignorant to the fact that Danny was even carrying a weapon. One thing that I am going to deviate from here is that in something that you mentioned earlier, there's a lot of things that are wrong there. First of all, there was a planned robbery he was asked to participate in, but that was happening on January the 1st. This happened on January the 2nd. The plan ended on January 1st when my brother and the person who was actually killed in the thing, in the incident, they both called it off. The only person that didn't was the person who committed the crime, and he was executed back in 2002 for this. The second thing is he was not friends. My brother was not friends with Daniel Renault. He was roommate and had been roommate for like 3 to 4 months under circumstances that he wanted no part of. I just want that out on the record because everybody keeps saying that friend. No, he was not friends with my brother. Again, Danny was executed back in 2002, and I'm sorry, it just frustrates me. All of the mistruths that are out there with media. The death penalty, as Representative Leach stated, was reserved for the worst of the worst unrepented criminals, but my brother is not the worst of the worst, and he does not deserve to be executed for a murder that he didn't commit, didn't know would be committed. In fact, he doesn't even deserve to be where he's at after 25 years for something that he physically did not do. And when he heard the gunshot and went inside of the store, because he was waiting in the car, he was going to drive home like he had borrowed my other brother's truck. He was taking that home. Danny went inside and at that point on his own decided to go through with this. My brother had no idea that it was even going to happen at that point. Again, every time that I have spoken before this committee, I've asked you to please take a minute to think about the following: equal justice under law. And these words were written to be powerful, and so powerful that they were carved into the United States Supreme Court building. And the message that these words deliver when they're put together need to be given serious consideration by you when you introduce bills. To sentence a person to death who never committed murder is not equal justice, and to allow the person to sit in prison for 25 years or for life is also not equal justice. I can't even count how many people who purposely committed murder are out walking the streets at this very moment. Yet my brother is and still remains in a cell smaller than my bathroom, being ridiculed and verbally abused and tortured for over 25 years for what? My brother, like the majority of others convicted under this law, were poor and could not afford proper representation. And many were failed by their lawyers, such as my brother. This system allows prisoners to be put to death despite being represented by disbarred, suspended, or incompetent attorneys who even fall asleep during capital murder trials. And as with my brother's case, he was deemed a future threat to society by a discredited expert. They call him Dr. Death when it comes to being labeled to this future danger to society. So our system allows people like terrorists life sentences, but condemns a person who is factually innocent of murder to die with the law of parties. So again, this is not equal punishment. There are other people who await their own murder under the law of parties: Humberto Garza, Randy Halpern, Rudy Medrano, Juan Ramirez. These are just a few more of the law party cases that we have in Texas, each with their own degree of culpability, but none of these men committed murder, and the death penalty, again, is supposed to be reserved for the absolute worst. Another case is Kenneth Foster. He was commuted under Governor Perry before his own scheduled execution, but he's still serving life without parole, which is still honestly too much of a punishment for driving a car. Two others that I want to briefly mention is Robert Garza and Joseph Garcia. Both of these men were executed by the state of Texas already for murders that they did not commit. I'm friends with both the mother and the friends of these people, and I cannot tell you how much that we family members suffer because of this. We have had 2 different execution dates in my brother's case, and I still have nightmares. I have PTSD from telling my brother what I thought would be my final goodbye to him. Okay, so I know that I've gone over my time.
No, you have as much time as you need.
As a family member, I consider myself to be a victim of this crime, and so are all of the members of my family, my brother's daughter, his grandkids, his friends. There simply aren't words powerful enough to describe what we've gone through for more than 25 years. Emotionally, I'm in that cell with my brother, awaiting a death sentence every day. I'm right now worried about my brother's mental state. Amongst many other things, because he's often in physical pain and he rarely receives the proper medical care, like not just my brother, but many of those on the row. And so right now, like I just got a letter from him a couple of days ago that he needs to see a doctor and they're not allowing him to do so. And I'll let you read some of that. It's like personal and I don't want to put that out there for public, but you know, this is just another one of those things as death row people that we have to endure having our loved ones suffer constantly. And anyway, I'm sorry. Our stress just comes in many forms and from all directions. In addition to all of this, we as family members have been chastised, called names. We've had guns pulled on us. We've had people try to run us over with their vehicles. We receive hate mail and lots of other things, especially when our loved one is plastered all over the news, because the average person doesn't care to do the background research that's necessary. They do believe wholeheartedly the lies and the mistruths spread across the media, and all they see is the title convicted murderer. And then we become the entities incapable of love, feeling, or goodness. Make no mistake, we family members also become the monsters that they portray our loved ones to be. And as a result, we have lost jobs, income. Some of us have had to move several times. My brother's daughter tried to commit suicide. Other family members that I know that I'm friends with, you know, they rely heavily on alcohol or illegal substances. Because how can it not affect you? How can it not? I've had to personally take depression and anxiety medication, especially around the times of, you know, execution dates. I should still probably receive counseling. I do have PTSD, and I could really speak for hours about this, but I'm asking you for your help. Please initiate a fair and open dialogue about the capital punishment system, to speak about issues such as executing the innocent or the exorbitant cost of the death penalty or the biased and arbitrary way that the punishment is meted out in Texas. We need you to support alternatives that punish the truly guilty and protect society without resorting to state killing, especially in law parties cases. Further, you need to be made aware of the emotional toll that is taken, you know, on all of us. But I'm asking you to go with your conscience and go as what is right. I realize that your constituents sent you to legislature and that you must represent them, but you're also a trustee of the entire state. And sometimes a hot issue like this one presents nearly irreconcilable conflicts among these responsibilities. But you still have to come to a decision and vote. It may not please everybody, but you should not only represent your constituents by listening, but also represent them by leading and by shaping opinions. The time for angry mob justice should be over. In addition to voting favorably for this bill, I'm asking that you put together some kind of committee and really sit down with the leaders of the abolition groups and the members of the families who come to visit your office. If you're not willing to seek to end the death penalty at this time, then you should, at the very least, provide a moratorium on executions until there is a time when the entire Texas legislature can hear and participate in dialogue about our state's capital punishment system. Since 1973, 190 former death row prisoners have been exonerated of all charges related to wrongful convictions that put them on death row. But how many were not so lucky and were wrongfully murdered by our system? As long as there is human error, there should never be an irreversible punishment. This is a life or death issue, and I'm not willing to sacrifice my brother.
Ms. Bean, thank you very much for, I know that Mr. Leach had.
Terry, I just thank you for being here. I know you had to move some things around to be here. Tell your brother hello for me. If there are some health issues that he needs help with, you know what to do. Just call me, and we'll get those fixed.
I'm supposed to tell you thank you, by the way.
Well, it's been 7 years since I first learned of your brother's case, and I'm more committed, like a rabid dog, to seeing justice done in his case than I ever have been. Members, I do want to reiterate that you can be a death penalty supporter and support this bill. This bill does not weaken our capital punishment system in Texas. There are some abolitionists who don't believe in the death penalty who support this bill, and there are people like me who do support the death penalty who actively, passionately, energetically support this bill. I think by way of passing bills like this and having conversations like this, we strengthen the system. We make it more trustworthy for all Texans. And so anyone who says that this, including our colleagues on the other side of the building, who some of whom may bury their heads in the sand and say, well, I'm a supporter of the death penalty and this weakens the death penalty. That's BS. It's just not true. It does the opposite. And so, Terry, thank you for being here. Mr. Chairman, thank you for the opportunity to lay it out.
Absolutely.
Any questions?
Thank you. All right. Thank you very much for taking the time, and I appreciate you sharing some of those very difficult things with us. I think it's important, members, as you kind of go through this process, and Jeff and I have been through this a few different times now, but spend time with those family members of victims of crime, but also spend time with the family members of folks that are serving on death row or incarcerated otherwise. Spend time with them to understand the ripple effects that this touches, so in the way it touches lives. It will definitely change the way you approach this, the more time you spend in those very difficult conversations. Is there anybody else wishing to testify on, for, or against House Bill 17? You told me he's not. Mr. Emmerich said he did not intend to testify on this bill. Not here. Sorry, I had a glitch. I've got another witness that's popped up here. Jessica Dickerson. Okay. All right, is there anybody else wishing to testify on, for, or against House Bill 1736 at this time? Chair seeing none. If there's no objection, House Bill 1737 will be left pending. Is there any objection? Chair is none, and House Bill 1737 will be left pending at this time. 1736, I apologize. Record will reflect the 1736, the bill we're hearing, and we just penned it. Got ahead of myself. Mr. Harrison, would you come over here and preside?
I've got, do you want me to do 1737?
Mm-hmm.
Thank you. All right, the chair lays out HB 1737 and recognizes Representative Leach to explain the bill.
Thank you, Chairman Harrison, Vice Chair Cook. Thank you, Chairman Moody, as well, for the opportunity to lay out House Bill 1737. Members, under current law, Texans are entitled to clear minor, low-level criminal records, but they face unnecessary barriers due to a costly and complex process. Folks are not notified when they're eligible for relief, and the process is difficult at best to navigate without legal assistance, which most cannot afford. This elaborate process puts Texans' ability to gain employment, public assistance, educational opportunities, and more in jeopardy. This bill addresses those problems and helps eliminate those obstacles. Members, House Bill 1737 remedies these issues by laying out a process for eligible first-time offenders who have committed nonviolent misdemeanor offenses, again, nonviolent misdemeanor offenses, to have their records automatically sealed after they successfully complete supervision and their charges are dismissed. This process uses technology to automatically identify people who are entitled to relief in the DPS criminal history system. That information is then provided to the courts so that those Texans who are seeking to clear their records will no longer have to initiate the process or pay any fees. Members, this is unlike expunction in that this record sealing will not destroy the record. This remedy strikes the right balance between, on one hand, maintaining the information for law enforcement and other limited uses, while at the same time, and on the other hand, clearing a path for people to successfully find employment, for them to find housing, be able to buy a car, other key sources of stability. And ultimately, this will, I believe, and we've seen this in other states too, substantially and significantly reduce recidivism and at the same time increase public safety. Similar legislation that implements system-based automatic record clearance has already been passed in other states like Pennsylvania and Michigan. I know we typically in Texas don't like to copy what Pennsylvania and Michigan do, but in this instance, they've gotten it right. Other states like Utah. There are 7 other states campaigning to implement similar legislation. And as we've seen so often, members, that when Texas leads on an issue like this, other states will follow. And I believe that this law is just like that. There are too many Texans who fall into this second chance gap, as we call it. The difference between those who are eligible for relief and those who are actually receiving it. This legislation will serve to decrease that gap, to make it smaller, to make the playing field more level and fair, and this will help provide economic opportunity and true justice for Texas families. With that, I'm happy to answer any questions, and I would respectfully request the right to close.
Thank you, Representative Leach. Members, are there any questions for Representative Leach? Okay. If there are no questions, we can go ahead and go on to testimony. And the chair is going to call first Nikki Presley. Thank you. And,
Thank you, Chairman.
You bet. And before you just start, do you mind just stating your name, who you're here on behalf of, and if you're testifying on, for, or against the amendment?
Yes, my name is Nikki Presley. I represent the Texas Public Policy Foundation and Right on Crime, and we are in support of HB 1737. This bill has already been passed by the House last session with only 1 no on the House floor. And I just want to reiterate what Chairman Leach has already said, but this automating of the non-disclosure process would remove barriers for individuals, and it's good for the economy and also public safety because it reduces recidivism. And Pennsylvania was the first state to pass clean slate legislation in 2019, and it has already helped over 1.2 million people obtain a record clearance that they were already eligible for. Additionally, there have been other states such as Oklahoma last year passed this, Utah and Virginia have all passed similar legislation. And I just want to emphasize that this bill doesn't expand who's eligible, it's just for those who are already eligible, and it's automating that process and removing the barriers. So thank you for your time, and I'm happy to ask any questions.
Thank you.
Answer any questions, not ask questions.
Even better. Members, any questions for the witness?
Thank you, Nikki.
All right, thank you. Okay, the chair calls Tara Tucker. Hello.
Hi, good afternoon.
Thank you. Before you start, do you mind just stating your name, who you are here on behalf of, and if you are on, for, or against the bill?
Yes, my name's Tara Tucker. I'm the Texas State Director for Alliance for Safety and Justice, and I am testifying for House Bill 1737. As I said, I'm testifying for Alliance for Safety and Justice. We're a multi-state organization that aims to win safety priorities that break cycles of crime and reduce rehabilitation, aim to increase rehabilitation and successful reentry into communities. We bring together a diverse group of survivors of crime to advocate through our flagship project, Crime Survivors for Safety and Justice, and advocate for strategies that stop cycles of crime, reduce our reliance on incarceration, and increase services for survivors. I'm going to keep this brief after this because we have some survivors here to also testify. Representative Leach did do a great job laying out that bill. And this bill did pass last session, 131 to 1, 142 to 1. And it really does do a great job of reducing barriers and giving people that opportunity to become gainfully employed and access housing. Our research team has done some research and found that old records can cost Texas more than $32 billion in lost wages for people who are either not given jobs or paid less wages than their worth. And so by reducing these barriers and clearing these records, people can then earn more money and take better care of themselves. So with that, if you guys have any questions, I'm happy to answer it.
Thank you. Any questions for the member or from the members? No. And just do want to clarify that we only have this bill in front of us at the moment. Thank you very much. Okay. All right. The chair calls Sarah Mae Jennings.
Good afternoon.
Good afternoon. Thank you. Do you mind saying your name, who you're with, and if you're on, for, or against the bill?
Sure.
Thank you.
My name's Sarah Mae Jennings. I'm with the Texas Fair Defense Project, testifying on behalf of myself and for the organization, and I'm for House Bill 1737.
Thank you.
I'm here to express my very strong support for House Bill 1737, which will actually automate non-disclosures that are already presumptive under Texas law, under Texas Government Code 411.072. 1 in 3 Americans has a criminal record, including over 15 million Texans. Individuals with records face lifelong barriers to housing, employment, public assistance, educational opportunities, and more. After successfully completing a special type of community supervision called deferred adjudication for certain first-time nonviolent misdemeanors, Texas law provides for an order of nondisclosure under Texas Government Code 411.072. An order of nondisclosure seals a record or portion of the record from the general public while remaining available to sensitive fields, including law enforcement agencies, financial institutions, healthcare institutions, and licensing agencies. In a petition-based record clearing system like Texas's, only 6.5% of eligible individuals are actually accessing that record clearing relief that they're entitled to under the law. There's no right to counsel for criminal record clearing. Record clearing is incredibly complicated and costly to attain. House Bill 1737 seeks to address these issues by automating those non-disclosures that are already presumptive under Texas Government Code 411.072. In 2015, this legislature passed what is now 411.072 into law through Senate Bill 1902. The intent of this statute was to streamline the non-disclosure process as much as possible for certain people without the need to file a petition. However, non-disclosures still remain inaccessible for people who qualify already under 411.072 because there are no processes in place. Sometimes 411.072 non-disclosures are called automatic non-disclosures, but practically speaking, all the law currently does is make someone automatically eligible for the relief, automatically qualifying them. It does not mean that they're actually accessing that relief. What we really need and what this bill before you finally does is automation. This bill will make the intent of Senate Bill 1902 actually come to life, allowing those Texans who already qualify for non-disclosure relief under the law to access improved employment and housing opportunities for themselves and their families without the help of an attorney. Thank you for your time. I'm happy to answer any questions.
Thank you. Members, are there any questions for the witness? Representative Leach?
I don't have a question.
Oh, sorry. Mike.
I do.
Oh, right there. Brother. Thank you.
Yeah, I just wanted to ask the practical effect. And so if you're talking about someone that's applying for the job or applying for, you know, a lease on an apartment or things like that, what are they to put on their applications? You know, are they?
I would have to consult the exact application. That's generally what I'm telling people when they come back to me and ask about what exactly I'm disclosing. Generally, those applications, though, are asking about convictions, and so we're not talking about convictions in the cases that we're looking at for this bill.
Yeah, I just want to make sure that 2 years from now, we're not still talking about it not being implemented because of the, you know, practical effect of the, you know, I guess the defendant or the applicant not knowing how to answer those applications.
Oh, I see.
So and that's just, you know, just an observation. I just want to make sure that it's having the intended effect, and I do support the bill. Okay, thank you.
Thank you.
Dave can answer it.
Okay.
Sarah, thank you.
Oh, yeah.
Members, any other questions for the witness?
All right. Thank you very much.
Okay, at this time, the chair would like to call Clarence Watson.
Good afternoon. How you doing?
Hey, Clarence.
So,
Welcome. Do you mind stating your name, who you're
yes, sir.
testifying on behalf of, and if you're on, for, or against the bill?
okay. My name is Clarence Watson, and I'm a crime survivor. And I'm the co-chapter coordinator of Crime Survivor Safety and Justice. Thank y'all for letting me be here today. I am testifying in support of House Bill 1737. This bill, if passed, would allow individuals like myself to start the healing process. To heal, people need to feel secure in their homes, secure in their jobs, secure in their communities. My purpose is to mentor young men and women to keep them on the path of excellence. But my reach is limited because of a mistake I made in 1993. And it's been a struggle since. Because of my record, I'm limited on what kind of work I can do. Even with the possibility of having a degree, because 92% of employers conduct background checks, making it difficult to set career goals when I could barely put food on the table. Having a record available to public hinders my ability to provide shelter for my family because landlords can legally discriminate against people with records. Taking application fees up to $200 and then learning through text or emails that I've been denied because of my background and never seeing that money again. I'm a crime survivor and a person with a record, which makes me highly interested in recidivism. Stable employment is what gives people purpose. It offers people responsibility. It gives people the source to succeed and provide for their families, and the best tool to reduce recidivism rates. At this point, 43% of people released from incarceration are rearrested in 1 year, and 77 people released from incarceration are rearrested in 5 years. What does this mean? It means people are being released with the intention to do right and change their lives, but because of limited resources like housing and employment, they feel the only option is to return to the illegal activities that they were incarcerated for in the first place. Whether it be dealing, stealing, or victimization of their families, this bill can help break those cycles. I've never claimed to be perfect, and I'm sure most of you have made mistakes, but we all deserve a second chance. This bill, and I understand that it's for low-level misdemeanors, but if passed, it can give people the opportunity to correct their lives, correct their past, help secure stable housing and employment, and focus on the real issue, raising our kids and setting career goals and being a resource for our community. Thank you. I appreciate you.
Great job.
Thank you. Members, any questions? All right, thank you very much. The chair would like to call Tracy Walton. Thank you for being here. Do you mind stating your name, who you're testifying on behalf of, and if you are on for or against the bill?
Sure. I'm Tracy Walton, and I'm here representing the SLC, and I am in favor of House Bill 1737.
And that's the Statewide Leadership Council, is that correct?
I'm sorry?
The SLC, that stands for?
I'm sorry, Statewide Leadership Council.
Thank
I
you very much.
apologize.
No worries. Thank you so much.
Thank you so much. I'm here to talk to you about a personal story about my life and my son. I am no stranger to trauma. My son's father was killed when he was 5 and in a car accident. And so my son struggled for a long time and, with behavioral incidents and, situations like that. And he made a mistake. And in fact, 10 years ago this year, my son's life changed forever. He was 18 years old and received a Class B misdemeanor. Today, my son is 28, and he's a father of 2 beautiful children, and he's sober. However, his life is not easy. It's very hard. The things that are so simple are not even simple for him. It isn't easy, and everything he has is because he has to earn it the hard way. He received a promotion at work, which required him to move to Fort Worth. Each day, his job, he's trusted with a lot of cash and interfacing with customers to build new business. Yet he's unable to do the simple things, such as get an apartment, get another job, buy a car. All of these things he requires assistance for. This is where House Bill 1737 would benefit people like my son. Sadly, in the state of Texas, he's confined to a set of rules that basically set him up to fail. Everything for him is harder. He can't get his own place to live in. Finding a job isn't easy when you have a Class B. My son was lucky. He found an employer who embraced him despite his charges. They saw the human and not the record. If this bill passes, it will create hope in an arena where there is none. If this bill passes, people will be less likely to engage in criminal activities because they have something to strive for. It will create hope that their mistake will no longer follow them. It gives the person something to work for. It gives the person their life back. Passing HB 1737 would automatically seal his record, which means it will no longer haunt him. It means he gets control over his life now. It's essentially a second chance. The mistakes we make when we are young should not define our entire lives.
Thank you very much.
Thank you.
Members, any questions for the witness?
Thank you very much.
All right. Thank you so much. All right, at this time, the chair would like to call Pamela Bryant. Hello. Do you mind stating your name, who you are here on behalf of, and if you are on for or against the bill, please?
Okay. Good afternoon. Thank you for this opportunity to speak. My name is Pamela Bryant, and I am a member of Crime Survivors for Safety and Justice. Okay.
And are you for, on, or against the bill, please?
I'm for it.
Great. Thank you so much.
Okay. You ready for me? So I wrote this out, but a lot of people and I already kind of said what about it, right? So I just wanted to say why I think you should. I'm a mother and I'm a grandmother of 5 granddaughters. I have 1 daughter and 2 sons. My son is the one who have all those children. So I was thinking about my granddaughters when I stood up there because I am a survivor, plus I am a person with past problems, right? So I have done everything. I'm the witness that if you can help me get this, you can do that. So the reason why I think the bill should, HB 1737, should, because I have worked so hard to get where I am. And if my granddaughter caught a misdemeanor because of assault or anyone, woman or man, I wouldn't want them to have to work as hard as I have. I prepared lunch and dinner for the homeless before I got up at 5 o'clock this morning to get prepared for this. I worked 2 jobs. I did just like Mr. Watson said. I filled out every application, and every application said no. I also take care of my 2 mentally challenged sisters that are older than me. Now, I'm not a victim with that part. I'm victorious. So I stand here asking for people to pass this bill because I'm laying the track for the people that are coming behind me to say that I can do it, but they probably wouldn't have to work as hard as I do. I'm 50 years old. It might don't look like, but these legs feel like it. Every morning I have to turn over and work a little little harder than everybody else for my children and my grandchildren. And just a misdemeanor, you know, to help them first-time people, because I got in trouble 2002 and the first time ago, and it wasn't this type of system to help me. You know what I'm saying? So if I could just say something to help, y'all could vote on it for someone else where they won't have to go through so much as I have been through, trying to get a place to stay, trying to take care of your family and this and that. And I have granddaughters, and they're coming up before me and their friends. Because, you know, these days they might be at a little party or doing something in college, and they might just don't get in trouble. And then they have this to go behind them. So if y'all could vote on it and give them the first, you know, the community supervision stuff, and then they could do better. But I am with crime survivors, so thank y'all for letting me share.
Thank you for being here. Any questions from members? Okay. Well, it's also great. Thank you very much. Thanks again for being here. Okay. At this time, the chair would like to call Melissa Perez.
Good afternoon.
Good afternoon. Thank you for being here. Do you mind just stating your name, who you are testifying on behalf of, and if you are on for or against the bill?
My name is Melissa Perez. I'm here with Crime Survivors for Safety and Justice. I thank you for the opportunity to speak on support of the House Bill 1737.
Thank you.
To implement automatic orders of non-disclosure for criminal history records information for those individuals meeting the criteria outlined in this bill would clear a pathway that would allow for jobs and housing that at this time are being denied. I myself am a formerly incarcerated individual. I was incarcerated in 1992, coincidentally under the law of parties. This month makes up 9 years. And I can attest to having encountered daunting obstacles of being denied employment and not being able to even rent an apartment in my own name. I can attest to the overwhelming feelings of helplessness and belief that punishment will never end for me. Independence, relocation, and self-sufficiency are vital to one's success. Individuals who sincerely desire to become functioning members of society who seek to avoid the toxicity and dysfunction of former associations, and oftentimes it even means with family. In order to pay for housing and expenses associated with our everyday life, we need better paying jobs than just labor with minimum wages. Reentry is offered to those who are displayed the ability and the potential to amend their thinking and their actions, and when they're faced with the continuous denials for beneficial employment and clean, safe housing, the feelings of failure and desperation, we can't help but set in. Parents are trying to do better with their lives. Some women, as single mothers, have to get their children out of CPS. But in order to do that, they have to hold a job and they have to provide housing for those children. And for many other people, they've earned their release back into society, and they deserve at least a chance to succeed. Yet neither beneficial employment nor decent housing are reasonably obtained to any measure of success when denial is being based on a documented past that's casting a forever shadow over your present and your future for those with criminal backgrounds. And the stigma that is associated with the mention of incarceration on those background checks, it negatively influences employers and property managers. What this message is sending out to the formerly incarcerated, the ones who have earned their release back to society, is basically it being translated that reentry back to society is a predetermined conscious challenge designed for us to fail. I try every day not to fail, and I promise I would never lose anything ever again. I'll be in a law of parties based on decisions that other people's made for me. And to have 9 years, I do have a little house I'm renting. I do own a little car, and I have a nice job in a corporate office at Collins Home Plus in Houston, Texas. But I fear every day that someone's gonna hear me say something out of step, and they're gonna know where I was, and I'm gonna lose my job, and I'm gonna lose my car, and I'm gonna lose my home. And Senator Jen Whitmire said years ago that if they do the crime, they must do the time. But when they do their time, let them out and become tax-paying members of society. But to do that, to be hireable and considered for lease on housing, the non-disclosure criminal history of qualifying individuals needs to be made into a law. That's all I have.
Thank you for being here. Members, any questions for the witness? Okay, thank you so much.
Thank you so much.
All right. At this time, the chair calls Russell Schaffner. Thank you for being here. Do you mind just saying your name, who you're testifying on behalf of, and if you are on for or against the bill?
Thank you, Mr. Chairman, Mr. Vice Chairman, committee members. My name is Russell Schaffner. I'm an Assistant County Administrator with Tarrant County, and I'm on the bill. And I had some concerns and questions about some of the language in subsection F of the bill related to the $28 fee. Between the kiosk and the hearing, I was able to speak with Chairman Leach, who agreed to work with us potentially on some of the language, and just wanted to thank him publicly for that, and look forward to working with your office, sir. So thank you.
Thank you. Members, any questions? Thank you for being here.
Thank you, sir.
You bet. Thank you. At this time, the chair would like to call David Emmerich.
Thank you, Mr. Chairman. I apologize for the confusion earlier on the other bill. I haven't fully adjusted to daylight savings time, so it takes me a little
No
while.
worries. Appreciate you being here. Do you mind just stating your name, who you're testifying on behalf of, and if you are on, for, or against?
Yes, I'm Dave Emmerich. I'm the Executive Director for State and Local Government Relations for JP Morgan Chase, and I'm here in favor of the bill on behalf of the firm. And I would like to take an opportunity just to address the committee about this issue from a perspective of employers in the state of Texas. JP Morgan Chase proudly employs over 30,000 people across the state. We have roughly 500,000 business customers, and we're one of the largest private employers in the state of Texas. As we've heard across the country, 78 million people, or roughly 1 in 3 Americans, have an arrest or conviction record that can significantly impact their ability to get a job. The drag on the earning potential of tens of millions of Americans has an even larger economic impact and economic consequences to them and their families. A recent Brennan Center study found that an average person with conviction misses out on roughly $100,000 in earnings over the course of a career. Someone who's been imprisoned as a young adult can, regardless of the offense, can lose out of nearly $500,000 in earnings. Research has found that the criminal record alone can reduce the chances of a second interview by 50%. JP Morgan Chase is committed to giving people across the country a second chance. In the last 2 years, roughly 10% of our new hires are justice impacted employees. In 2001, we hired more than 4,300 people with criminal records whose criminal justice involvement had no bearing on the job requirements that they were seeking. We've also taken a number of steps to broaden our hiring practices among the company. We banned the box by removing all questions about criminal records from our job application in the U.S. We do not conduct a background check until a conditional offer of employment has been made, which means we are pretty sure we've identified the right candidate and make that offer. And then we've developed a hiring model to work with the community and legal aid organizations to proactively develop a pipeline of potential employees with criminal records whose histories fit within industry guidelines to fill open jobs and pathways. We've also committed $12.5 million to community organizations in several cities, including Houston and Dallas, to connect people with criminal records with in-demand, well-paying jobs and the tools and resources they need to achieve their financial goals and entrepreneurship training. In addition, in 2021, JP Morgan Chase helped launch the Second Chance Business Coalition, which has grown to more than 40 large companies committed to expanding hiring and advancement for practices for people with criminal records within their firms. Many of these companies are household names and have a presence in nearly every community across the country and the state. In the state of Texas alone, an estimated 1 in 4, at least 7 million people have criminal records of some sort. Of those, 4.4 million have a felony or misdemeanor court conviction. An estimated 3.6 million, or 82% of those people, are eligible for expungement or sealing of their records. Unfortunately, of the 3.6 million that are eligible, roughly less than 5% attempt to go through the expungement or record sealing process. The petition based process is expensive, it's costly, it's completely, it's complicated and time consuming. It just doesn't work for the state. We believe that second chance hiring will bolster the economy, it will help fill jobs that are much needed in the state, and we believe that folks that have fulfilled their criminal justice obligations should be able to get a job. I thank the committee for its time. I thank the chairman Chairman Leach for continuing to work on this important issue. I'd be happy to answer any questions.
Thank you very much. And just to clarify for the record, because there was some confusion earlier, we only have this bill 1737 in front of us.
Correct, only 1737.
Thank you very
and
much.
I do have an answer to your question you had earlier, Mr. Roberts.
Please.
If they've had their records sealed or expunged, there's no obligation for them to check the box or to disclose that on an application for a job or for housing or apartments.
Yeah, I guess the concern is just making sure that that they don't answer no, and then
Right.
background check comes back and they look like they're lying,
If the background check, if the record's sealed, then that would not show up on their record, but they're not obligated to check that box.
There's a lot of private background companies out there.
That's
that
true.
May or may not have updated records, but yeah, I feel like, obviously it's good policy, I'm glad we're doing it, but I bet you there's gonna be some glitches until we get it all going.
Great.
Not a reason not to do it, though.
Absolutely.
Vice Chair Cook, any other members, Representative Leach?
Yeah, I don't want to belabor the point, but members, I just want to affirm and thank you, Dave, and JP Morgan Chase. We talk about criminal justice reform. The business community is waking up to this. Employers of all sizes are engaging when it comes to second chance hiring and bills just like this. I can think of no better example of that than Dave and JP Morgan. And so just want to say thank you for leading by example. Really
Thank you. I've said in the past that we're a highly regulated national bank. If we can do it, just about anybody can.
Absolutely. Well said.
Thank you. Members,
Thank you.
any other questions for the witness?
Thank you.
Okay, thank you. All right, is there anyone else who wishes to testify on, for, or against HB 1737? If not, Chair would recognize Representative Leach to close on the bill.
I close. Thank you, members.
All right, thank you, Representative. If there's no objective, HB 1737 will be left pending. Is there any objections? Chair hears none. HB 1737 is left pending. At this time, the chair would like to lay out HB 1589 and recognizes Vice Chair Cook to explain the bill.
Thank you, Mr. Chairman and fellow committee members. 204, that's the number of people who were killed by an intimate partner or stalker in Texas in 2021. 169 women and 35 men were killed in 2021 by an intimate partner. Family violence destroys children, destroys families, and destroys communities. In my own practice, I've often been confronted with the aftermath of family violence in my own cases. Currently, when a defendant is arrested for community family violence, bond conditions and protective orders can be used to protect family members while the criminal case is pending. If a defendant is found guilty of committing family violence, currently the penalty is a Class A misdemeanor. If the defendant has a prior conviction, the punishment can be increased to a third-degree felony. However, there's a gap in the law that we need to close, and it starts with this committee in getting that gap closed. Under current law, when there's a violation of a bond condition or a protective order that's currently in effect, and there's a second act or a second crime that's committed with regard to another act of family violence, currently prosecutors cannot use that second act in order to seek a penalty enhancement to a third-degree felony. Family violence does not happen overnight. It's a pattern or behavior. And members, this is happening in my community and as yours as well. House Bill 1589 gives prosecutors the tools to demonstrate a pattern of dangerous behavior and protects victims. One victim of family violence is too many, let alone 204 lives that were lost in Texas in 2021. Mr. Chairman, I'm available for questions from this committee, and I would like to have an opportunity to close when appropriate.
Of course, thank you very much. Members, are there any questions for Representative Cook? All right, seeing none, we can go ahead and proceed to testimony. And at this time, the chair would like to call Lindy Borchardt.
Chair Harrison and members of this committee, I'm Lindy Borchardt. I'm an Assistant Criminal District Attorney in Tarrant County. And on behalf of Phil Sorrells, the Criminal District Attorney, I fully support HB 1589. As Vice Chair Cook correctly recognized, family violence destroys our communities. Family violence destroys our homes, and that's especially true with repeat family violence offenders. And this bill is addressing repeat family violence offenders. I say it's a cleanup bill because it was an oversight. As Vice Chair Cook correctly stated, family violence is a Class A misdemeanor, but there's an enhancement provision. And the enhancement is if they'd previously been convicted of family violence. It's, it's increased to a third-degree felony. If it involves family violence strangulation, then it's increased from a third-degree felony to a second-degree felony. The cleanup bill is for those prior convictions where they were convicted of a violation of a bond condition set in a family violence case or a protective order. And that violation is based on them committing family violence. And that would be now an enhancement under this bill, because currently somebody can commit family violence. It can be a violation of the family violence bond condition, and it can't be used as an enhancement because the prosecutor went forward on the violation of the bond condition or a violation of a protective order. Had the prosecutor gone forward on the underlying act of family violence, it would be enhancement. And that's not good, sound criminal policy. That doesn't protect our families that really need protection from family violence and the devastating effects of family violence. Are there any questions?
Members, any questions? Not seeing any. Thank you very much.
Thank you, and thank you, Vice Chair Cook.
Thank you.
And Chair Harris.
Okay. No, thank you. Are there any, is there anyone else who wishes to testify on, for, or against HB 1589? Okay, if not, the chair would like to recognize Vice Chair Cook to close.
Thank you, Chairman Harrison. And I would like to thank the Tarrant County District Attorney's Office for bringing this bill to my attention and having an opportunity to work with their office in getting this loophole fixed. And so, members, I would appreciate your favorable consideration, and I close.
Thank you very much, Representative. If there's no objection, then HB 1589 will be left pending. Hearing none, the chair hears none. 1589 will be left pending at this time.
The chair lays out HB 1385 and recognizes Chairman Moody to explain the bill.
Thank you very much, Chairman, members. There was a time when criminal justice and the policy around it was largely driven by feelings rather than facts. We've been moving away from that in favor of evidence-based practices, and the results across our system speak for themselves. It turns out that when you use hard data to see whether what you're doing is working, you actually get better results. House Bill 1385 is about exactly that. Our local governments, especially in larger counties, contract with researchers in both other government agencies and in the private sector to track recidivism rates and evaluate the efficacy of both pretrial and post-conviction programs. That helps local governments develop best practices and plays into things like program design and the use of criminal justice resources on the whole. Interestingly, this is data that was once freely shared with local government. But last year, DPS changed the way they were interpreting the statute amended by the bill and began withholding this information. HB 1385 will get that data shared once again and help our state make better policy. Members, I'm happy to answer any questions at this time. If not, I'd ask to be recognized to close when the time is appropriate.
Members, are there any questions for Chairman Moody? Here none, we will proceed to testimony. Thank you. The chair calls Rosie Medina. That's 1385. I think Rosie Medina shows that she's in support of this bill, but not testifying. Is that clear, or is that correct? Thank you. The chair calls David Stout.
Good afternoon, Mr. Chair. Honorable members, my name is David Stout, and I serve as County Commissioner in El Paso, Texas. I represent Precinct 2, and I'm here representing El Paso County in support of HB 1385. I want to thank Chair Moody, first of all, for carrying this bill for us. I think Chair Moody did a great job of describing the need and purpose of this bill. But the key point that I want you all to take away from my testimony is that if the state does not share this data, It will keep us from continuing the historic progress that counties like El Paso have made in this area. The County Uniform Recidivism Measure Project represents the first time in Texas history that county recidivism measures have been developed using a uniform methodology. With this information, we can better identify areas in need of further examination and improve the effectiveness of policies that are aimed at reducing recidivism. This project began in 2013 based on the interest and initiative of criminal justice planners in Bexar, Dallas, El Paso, Harris, and Tarrant counties. Each county contracted with Dr. Tony Favello to develop 1-, 2-, and 3-year recidivism measures for individuals released from county jail and the state population supervised by the county. Dr. Favello could not have done this major project without information from DPS. And we're not really asking for anything new, only that the state continues sharing this data with us. For some reason, it stopped last year, and we need the law to be more clear in requiring the state to share this critical data with local governments. My county has been a leader in this project, using everyday findings to identify program areas for improvements. Our reports track 3-year recidivism rates for jail releases and state population supervised in the county in 2011, 12, 13, 14, and 15, 2-year recidivism rates in 2016, and 1 year for 2017. And because the state refused to share data starting last year, we have been unable to update our recidivism outcomes past 2017. So with that, I respectfully ask that you vote this bill out of committee. Thank you very much.
Thank you. Members, are there any questions for the witness? If there's no other, thank you very much, sir.
Thank you, Mr. Chair.
Are there any others who wish to testify on, for, or against HB 1385? If not, the chair recognizes Chairman Moody to close on their bill.
Thank you. And I'm happy to provide some of the back and forth that county had with DPS about the interpretation of the statute. I really think it's just something that needs to be clarified. So I'm happy to delve into that further. Otherwise, I close.
Thank you, Chairman Moody. Are there any questions for Chairman Moody? No. Okay. If there's no objection, HB 1385 will be left pending. Is there any objection? Chair hears none. HB 1385 is left pending. Thank you. The chair lays out HB 1394 and recognizes Chairman Moody to explain the bill.
Thank you, members. Real quick, and I should have done this before I started my last one, just an apology to my witnesses from El Paso. I know they enjoyed spending the whole day with us today, but I probably should have started by letting them know that the typical procedure is to defer the chair's bills to the very end. So I should have told them that so they could have spent most of their day exploring South by Southwest and then come back to testify. But I appreciate everybody's patience. House Bill 1394, this is a bill about expanding access to drug and alcohol specialty court programs. Our specialty courts provide the highest level of supervision for moderate to high-risk offenders and provide rehabilitative services that greatly reduce recidivism. They're exactly what we think of when we consider the goals of probation. Specialty courts keep a close eye on offenders, get people back on track, and stop them from reoffending. Unfortunately, one of the bottlenecks for that is a statutory limitation on the kinds of offenses that can be sent to these courts. For both adults and juveniles, cases in which there's a weapon or even any use of force at all are excluded. This is a restriction that covers an enormous number of cases, and it's one that's been removed from more recently created specialty courts like those for our veterans, and it's facilitated greater participation and much better outcomes. HB 1394 will do that same thing for our drug and alcohol courts. What it does is make the prosecuting attorney and the judge the gatekeepers of these programs in cases that may involve the use of force, serious injury, or display of a weapon. Obviously, the judge has to agree to accept the individual into the program, even under the current law. And under HB 1394, the prosecutor would have to agree as well for this class of cases that are currently excluded entirely. In other words, this will apply in cases where everyone, judge, prosecutor, and defendant, are all in agreement that the specialty court is where the case belongs. With that, I'm happy to answer any questions, but we have some experts from El Paso who want to share some stories with you as well.
Thank you, Chairman Moody. Members, do they have any questions for Chairman Moody? Here none, we'll proceed to testimony. Thank you. Chair calls Zachary Pratt.
Good afternoon. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Zachary Pratt. I'm testifying on behalf of Harris County Juvenile Probation in favor of House Bill 1394. My capacity currently is supervisor of our drug court program in Harris County, proudly titled SOAR Court, Sobriety Over Addiction and Relapse. I'm here today to share with you, to kind of put in perspective current limitations within the bill as it is written. Research for year 2022 reveals that 157 youth were eligible for SOAR Court, drug court, based on exclusionary criteria history, as Chapter 123.002 currently outlines. Of the 157 eligible candidates, 72 were granted deferred agreements. This left 85 eligible candidates remaining in the pool. After further screening, candidates were then removed due to ineligibility based on criteria such as lack of substance abuse reported, less than 6 months of probation, currently in an alternative specialty group, or their age. In summary, 23 candidates were eligible for drug court for year 2022. The intent with the passage of this bill is to broaden access and provide opportunities for more youth to enroll in drug court programs and receive the necessary substance use services that may not be otherwise available to them. Although 23 is a great number, a great starting number, removing the current statutory requirements of use of force against a person of another, newly including discretion of the prosecutor and the whole party, drug court party, to allow participants entry into the drug court program helps further allow more youth to receive the valuable services that drug courts are known to provide. With that, thank you for your time, and I'm happy to answer any other questions.
Thank you. Members, do we have any questions for the witness? Oh, okay. Thank you very much.
Thank you
for being here. The chair calls Sam Medrano.
Good afternoon. My name is Sam Medrano Jr., and I'm the judge of the 409th District Court. I'm here in support of this bill, and Chairman Moody is right. He didn't tell us anything about this as I got on a 5:30 flight from El Paso to come here this morning. So, but I am happy to be here.
Sir, are you testifying on behalf
in support of this bill?
In behalf of yourself?
As the judge of the 409th District Court that has run our juvenile drug court program for the last 18 and a half years.
Thank you.
One of the things that Chairman Moody has really addressed are trying to get our juvenile drug courts in line with our mental health courts and with our veterans courts. The use of violence is one of the things that has really been a hindrance to letting young men and young women into our program. My chief juvenile probation officer is going to talk about the fact that over the last 18 and a half years, with regard to referrals for assaults, 30% of those referrals also come with moderate to severe substance abuse issues that were not being able to be addressed because of this prohibition. These people who could have used those services at that time. The most underserved population in the juvenile justice system are our girls. And with regard to our girls, most of the referrals that come in El Paso come with regard to either theft or some type of situation in the household, fighting with a sister, fighting with a brother, having conflicts with parents. They come in at a much higher rate with regard to referrals for assaults. And it's still, we're looking at 30% of them who could have been helped and who will be able to be helped now. Our drug court program has been a mentor court program for the National Council on Juvenile and Family Court Judges. And this change, this bill is going to help provide more services. The young ladies that we've had, for example, that came in for substance abuse and we identified issues. We have family counseling, we have parenting classes, we have the ability to heal and make these families whole again. And so what the bill does that Chairman Moody has put forward really addresses some of the issues that I've seen in our community for the last 18 and a half years. Thank you for your time, and if there's any questions that I can answer.
Sure. Members, do we have any questions? Yeah, Chairman Harrison.
Thank you, Mr. Chairman. Thank you for being here. I certainly appreciate the spirit of this and other bills that are like it. A quick clarifying question. Would a potential unintended consequence of this particular bill be to have greater leniency for somebody who's convicted of perhaps a heinous or violent crime because they happen to also be under the influence or having drug paraphernalia on them at the time, more lenient because they get diverted to this, as opposed to somebody who committed the same violent crime but was completely sober and had no drug paraphernalia around them?
No, I don't believe that that's going to be a concern. Not only, we staff these cases under the guidelines that the laws give us, and also guidelines that we have implemented over the last 18 and a half years because of what we've seen in our community. And one of the most important members of that staffing has always been the county attorney's office that does prosecute in our community. So there's always been enough law enforcement involvement in trying to get these things done. And we really do a good job in our screening to identify exactly what the allegation or the adjudicated offense really is. So I'm comfortable that this is not going to give any leniency to the serious offenses that all of us are concerned about.
Thank you for your response. Thank you, Mr. Chairman.
Anybody else any questions for Judge Medrano? If not, thank you, Judge Medrano. Appreciate it. The chair calls Larry Phillips.
Thank you, Mr. Chairman. It's great to stay and want to thank you for bringing this bill. On behalf of, I'm here testifying Larry Phillips. I'm a district judge from Grayson County. I'm testifying for this bill on behalf of the Texas Association of Specialty Courts. I'm vice president of that. Our board of directors identified this bill as one that we want to support, and Rosa Medina is going to talk about that as well. She's our board member. She's in the probation department. As I shared earlier, our specialty court association is made up of all disciplines of those involved in the criminal justice system. And our president right now is a prosecutor, juvenile prosecutor. And so we are serious about providing opportunities for those that are struggling with addiction to make the right path and get out of a criminal background. I told you earlier, this is with the other bill, these programs are intense. They're focused. And what you're going to see is there are oftentimes people that should be in these programs, but because of the current way the statute's read, they're put on regular probation or on intensive probation. So they don't benefit from this tough, scientifically proven a pathway for them to have success. This will allow them to do that. As it relates to the adults, and that's what I'm going to talk mainly about because my specialty court's an adult. We also have a juvenile court. This is going to provide them a chance to have success, to return them to being contributing members of our communities. And there are often times that we think, gosh, we'd love to have that person, but because of that, the way that charge is we can't let them in. Even if the prosecutor says, you know, this makes sense in this situation. And so what this really does is I think it makes us consistent with what's happened in other states, but it also lets us be consistent with, we've got a group of professionals. We've got a judge who has to run for election. They're not going to let people in that shouldn't be there. We have a prosecutor who has to run for election. They're not going to let people in there that they don't want to be in there. And you have the rest of the team members. So I would, on behalf of the association, I would support this bill and ask you to favorably vote it out and be glad to answer any questions.
Thank you, Judge Phillips. Members, do we have any questions for Judge Phillips? No?
Thank you,
very
Mr.
much.
Chairman, members.
Chair calls Colt DeMorris. Okay, okay. Is there anyone else that wishes to testify on, for, or against HB 1394? Yes, please. Hold on 1 minute, sorry.
Rosie
Do you mind?
Rosie Medina.
I think you need to register for this one as well. I think you were registered for the other one.
I did, inadvertently.
Yeah, we have this bill in front of us just to clarify. Chair calls Rosie Medina.
My apologies for the confusion.
Okay, thank you.
So good afternoon, Chairman, committee members. My name is Rosie Medina, and I serve as El Paso County's Chief Juvenile Probation Officer, and I also serve as Director at Large for the Texas Association of Specialty Courts.
And you're testifying on behalf
And I am in
for.
support of, yes.
Thank you.
The updates proposed in the statute will afford juvenile drug courts across our state the opportunity to broaden our eligibility criteria to include youth who have been referred to the system for assault charges, otherwise, or as referenced in the statute, as the use of force against the person of another. Currently in El Paso County, and I went back and pulled the statistics back to 2004 when we began our program, looking up to current time, approximately 25% of all referrals coming into our system are for assault charges. Of those 25%, approximately 30% of the youth have been identified as having a moderate to severe substance use disorder, which is one of the criteria elements that we have to consider when determining eligibility for our programs. As the statute currently reads, this population is not eligible for participation in our specialty courts across the state. And our programs serve a very important piece in the continuum of juvenile justice because we afford youthful offenders with an opportunity to receive intensive supervision, intensive substance abuse treatment services, drug testing with judicial oversight. And we cannot neglect the fact that in these programs, we're not just treating the child, but we're treating the entire family. Our children are symptoms sometimes of a much larger problem, and that's the beautiful thing about the juvenile justice system is that we can provide, and we do provide, the entire family system with services. Currently in our state statutes for mental health and veteran courts, they do not prohibit violent offenders from entering specialty courts. However, youth are excluded. Juvenile drug courts across our great state afford youth between the ages of 14 and 17 the opportunity to remain in the community and receive intensive substance abuse treatment services without having to necessarily remove them from our community, send them to costly residential treatment programs to receive substance abuse services, or even sometimes commitment to TJJD. So ultimately, our specialty courts do divert and do save our state quite a bit of money. So with that, I ask for your favorable support of this House bill, and if you have any questions, I'd be more than happy to answer.
Thank you, Ms. Medina. Members, do we have any questions for Ms. Medina? If not, thank you very much.
Thank you.
Is there anyone else who wishes to testify on, for, or against HB 1394? If not, the chair recognizes Chairman Moody to close on his bill.
Thank you all very much. I appreciate you hearing the bill, and I close.
Thank you, Chairman Moody. Is there any objection to HB 1394 being left pending? If there's no objection, then HB 1394 is left pending. Thank you.
All right. Thank you, Chairman. Thank you all. Thank you, Judge. Appreciate it. Both Representative Harrison, Representative Bojani, I know that next week you'll be running your respective subcommittees, so I want to make sure I had an opportunity to make sure you remembered how to read a script. When in doubt, just defer to what's written in front of you. It's much like Anchorman. Although Rachel won't pull any pranks on you. So before we adjourn today, I do want to vote on a number of measures that we have, including some we heard today. Appreciate you all putting a lot of work in to review that stuff as they've come forward. Do you have my list? Oh, I have it. No, I'll explain it. And then this one has a sub coming, right? Okay. Yes. Okay. So it'll be the last one. Yeah, the last one. I got you. And not that it's a point of pride for y'all, but the first 5 bills that made it to calendars were from us. As of Monday, there were only 5 bills in calendars. They were ours. So the first couple calendars are going to be familiar bills for you all to see. All right. The chair lays out as a matter of pending business House Bill 180 by Moody. The caption reads, relating to requiring a court that sets an execution date to withdraw the execution date on the motion of prosecuting attorney with jurisdiction over the underlying case. Members, this is a bill that we heard last week. At this time, the chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. The chair moves that House Bill 180 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzwein.
Being 9 ayes and 0 nays, the motion prevails. Got it. Chair lays out as a matter of pending business, House Bill 205 by Moody. The caption reads, relating to an application for a writ of habeas corpus based on certain relevant scientific evidence that was not available at the applicant's trial. Members, this is a bill that we heard last week. At this time, the chair offers up a committee substitute. Is there objection to the adoption of the substitute? Chair hears none. The substitute is adopted. Chair moves that House Bill 205 as substituted be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzwein.
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business, HB 289 by Representative Jatan. Caption reads, relating to the 279 by Jatan.
279.
Is that the right number? Let me make sure that that's the right. Yep, okay. Because I've got this one here. Okay. Maybe don't read the script exactly how it says. Caption is relating to the prosecution and punishment of the offense of trafficking of persons. This is a bill that we heard last week, members. Is there any discussion? The chair moves that House Bill 279 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzwein.
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business, House Bill 393 by Representative Goldman. Caption reads, relating to restitution payments for the support of a child whose parent or guardian is a victim of intoxication manslaughter. We heard this bill on February 28th. At this time, the chair offers a committee substitute to House Bill 393. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that House Bill 393 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach.
Who's the author of this?
Goldman.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzwein.
9 ayes and, there being 9 ayes and 0 nays, the motion prevails. This time, the chair lays out as a matter of pending business, House Bill 409 by Representative Collier, relating to the governance and administration of the Texas Indigent Defense Commission and to certain disclosures made in relation to the provision of funding for indigent defense services. Is the bill that we heard last week. Members, is there any further discussion on this bill? Chair moves that House Bill 409 without amendment be reported favorably to the full House with the recommendation to be passed and be printed. Clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Oh, present. Okay. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
There being 8 ayes, 0 nays, and 1 present not voting, the motion prevails. This time, the chair lays out as a matter of pending business House Bill 598 by Representative Shaheen relating to creating the criminal offense of possession of an animal by a person who has been previously convicted of an offense involving animal cruelty. Members, this is the bill that we heard on February 28th. And we had a previous conversation about a committee substitute. This time, the chair offers up a committee substitute. Is there any objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. This is the provision that you all were asking and concerned about a timeline associated with the bill. And so that's what the substitute does. And I think the preference was for us to do this here in the committee rather than send it to the floor. So that's what we've done now. At this point, did I adopt this? I adopted the substitute, did I? Okay. Chair moves that House Bill 598, a substitute, be reported favorably to the full House with the recommendation that do pass and be printed, and the clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
There being 9 ayes and 0 nays, the motion prevails. This time, chair lays out as a matter of pending business, House Bill 842 by Representative Patterson relating to prohibiting the extension of the period of driver's license suspension for certain driving while license invalid convictions. This time, the chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. Members, Mr. Patterson did ask that we consider sending this local consent calendars. I'm going to inform him why that was a mistake to ask for that at this point in session. At this point, I'm going to move that House Bill 842 as substitute be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers.
Aye.
Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. This time, chair lays out as a matter of pending business House Bill 1161 by Representative Meyer relating to the confidentiality of home address information for victims of child abduction and to the administration of the address confidentiality program by the Office of the Attorney General. This is a bill that we took up in a hearing last week. At this point, the chair moves that HB 1161 without amendment. Here, without amendment be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. This time, chair lays out as a matter of pen. Now we're moving to bills that we heard today, members. Chair lays out as a matter of pending business House Bill 28 by Representative Slauson relating to enhancing the punishment for certain conduct constituting the criminal offense of aggravated assault. The chair moves that House Bill 28 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers.
Aye.
Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 1207 by Guillen relating to the statute of limitations for tampering with certain physical evidence. Chair moves that House Bill 1207 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers.
Aye.
Representative Darby.
Aye.
Representative Harrison.
Aye.
Representative Leach.
Aye.
Representative Christina Morales.
Aye.
Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. This time, the chair lays out, as a matter of pending business, House Bill 1300 by Mr. Guerin, relating to the punishment for the criminal offense of tampering with or fabricating physical evidence. The chair moves that House Bill 1300 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business, House Bill 1736 by Representative Leach, relating to the extent of a defendant's criminal responsibility for the conduct of a co-conspirator in a capital murder case and the review of certain convictions by the Board of Pardons and Paroles. Mr. Leach, do you have any other further comments on this bill?
It's a good bill.
Chair moves that House Bill 1736 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
Aye.
There being 9 ayes and 0 nays, the motion prevails. This time, what do you mean last bit? Okay, that's all I need to know. This time, chair lays out as a matter of pending business, House Bill 1737 by Mr. Leach, relating to the automatic orders of non-disclosure of criminal history record information for certain misdemeanor defendants following successful completion of a period of deferred adjudication committee supervision. Mr. Leach, any comments on this fine bill?
It's a good bill.
No, there you go. Chair moves that House Bill 1737 without amendment be reported favorably to the full House with a recommendation that do pass and be printed. Clerk, call the roll.
Chairman,
Yep.
actually,
Oh,
we did,
put your mic
One of the witnesses mentioned
They had a comment for you.
the issue of the fee, and then Judge Phillips as well mentioned another issue with maybe some cleanup language, and I plan to communicate with them, and if necessary, we'll do a floor amendment.
Okay.
That'll be acceptable to the author.
All right, well then, I'll re-urge my motion to have HB 1737 without amendment and be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk, call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
Aye.
9.
Being 9 ayes and 0 nays, the motion prevails. Members inadvertently left one off from a prior hearing. I want to go back to, and this time the chair lays out as a matter of pending business, House Bill 727 by Representative Rose. This is dealing with the applicability of the death penalty for those suffering from serious mental illness. And we don't have a substitute on this, right? It's just the bill as is. Okay. The chair moves that House Bill 727 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook? Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
There being 8 ayes and 0 nays, the motion prevails. All right, members, that's what I have for us for this week. For planning purposes, subcommittees will meet next week. If you're on those, please visit with your respective chairmen so they can tell you what you're going to be talking about. We will probably have a formal meeting only for the standing committee so that we can vote on any bills that we have pending that if they need to move. We'll make that determination over the next couple of days, but certainly don't want to lose the momentum that we're working on. So I want to thank everybody for their diligent work and digging into a lot of big issues. We have, I think, probably over 200 bills now in our possession. We're trying to get rid of some of them that we think are worthwhile. Thanks for all your time. So members, that concludes today's agenda, unless anybody has anything they want to comment on. No? If there's any, is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned at 4:11 p.m., subject to the call of the chair.